This is the regularly scheduled meeting of the Compliance and Amendments Committee, convening at 4:05. Mr. Rustin, would you call the roll, please?
Yes, Madam Chair. Member Washburn.
Here.
Washburn present. Member Snyder.
Present.
Snyder present. Member Nee.
Here.
Nee present. Member Wolf. Wolf excused. Member Johnson.
Here.
Johnson present. Madam Chair, we have a quorum.
All right. Are there any changes to the agenda?
No, Madam Chair, there are no changes.
Actually, I have one. The approval of the March 9th meeting minutes, I was reviewing the minutes for today. The other minutes, it seemed like we'd already approved them. Twice already, actually. So if we look, for example, at the August 10th minutes, page 7 of the packet, on page 8 of the packet, agenda item 2, they were continued, I'm sorry.
They were approved last meeting.
They were approved last meeting, okay, that's what I thought. Right, page 14 of the packet, agenda item number 1, they were approved last month. Are there any further changes to the agenda? Okay. Chris, would you call the next item, please?
Yes, Madam Chair. The next item is approval of the August 10, 2010 meeting minutes.
Move to approve.
Do I have a second? Is there a second?
Oh, sorry. I second.
Okay. Does anybody have any marked, Member Nee?
A couple of things. First of all, on second page of the minutes, page 9 of the packet, I believe the respondent, this is right at the top of the page, I believe the respondent in item 4 is BAVC, Bay Area Video Coalition, not the Department of Technology. I may be incorrect on that, but if you look down into the actual text of the discussion, you'll see that BAVC is really the one that's defending itself, including the fact that Chrisana Hodges represented BAVC. So I think BAVC, Bay Area Video Coalition, is the respondent. Also, in the next to last paragraph, the 5th line down, I believe the gentleman's name is Zeltzer, Z-E-L-T-Z-E-R. That's my recollection. Other than that, looks good to me.
At this time, I'd like to call for any public comment on the minutes. Seeing none, the matter is with the task force for a vote. Would you call the roll?
On the motion, Member Snyder.
Yes.
Snyder, aye. Member Nee.
Aye.
Nee, aye. Member Johnson.
Aye.
Johnson, aye. Member Washburn.
Aye.
Washburn, aye. Madam Chair, we have 4 ayes.
Mr. Rustin, will you call the next
Aye.
item on the agenda?
Yes, ma'am. Item number 3 is approval of September 14, 2010 meeting minutes.
Move to approve.
Do I have a second?
A second.
Any editing, any questions, comments from the members?
I have one,
Yes, Member Johnson?
just one typo. It's not a big deal, but it's in item 2 on page 14 of the packet. It says motion to continue matter to October 12th regular meeting minutes. You just need to delete the minutes.
Any further editing? Changes? This time I'd like to call for any public comment on the minutes from September 14th? Seeing none. Chris, would you call the roll, please?
Yes, ma'am. Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Madam Chair, there are 4 ayes.
Excuse me. Just a point of order. I believe you should be calling Member Wolf's name as well during the roll. If he's not here, I mean, shouldn't it be reflected that he's absent or excused on the vote?
Through the chair, I have been told to call his name once and then not to continue with it. It's only when he comes in, when the situation changes on you, we change the roll call.
Okay.
Chris, would you call the next item on the agenda, please?
Item number 4 is Ethics Commission proposed policy of handling sunshine-related complaints.
Member Nee has made the suggestion that we invite Mr. Grossman to join us as a non-voting member of the committee today.
Can I ask a question?
Sure.
I'm happy to do it. Do you want me up there or
Uh-huh.
down here?
Up here. Okay.
We know who you are.
You won't have to hop up and down so much if you're sitting up here with us.
I hope I'll hear better up here.
Okay. I'd like to spend a minute or so talking about process here and how we want to conduct our work this afternoon. Member Nee?
Yeah, Madam Chair, you might recall that when the task force held its special meetings on this matter, we weighed that question, and I believe the consensus at that time was to just take it section by section, move.
Okay.
And we call for deliberation among the committee or the task force on that basis, and then also invite public comment section by section. If somebody has a better, more efficient way to do this, I'm certainly open to that. The one problem we have is that this is a fairly thick document, and the commission, this is about 44 pages. And we have to bear in mind that it is very possible that the Ethics Commission will try to move this to a vote at its meeting in November. That would be, I believe, November 8th, if memory serves me correctly. That wouldn't leave us much time. What we might do is begin a couple things. Number one, begin our discussion today. Number two, call a joint meeting of this committee and the commission. And number three, at least one, not maybe more. And number three, ask the commission. I could send a letter to the commission asking that the decision be put back until such time as we have had a chance to go through it, and also we have had a chance to have any necessary and desired discussions with the commission.
Okay, so logistically, do we want to ask for that extension now, or see how things go today? And
Well, let's see how things go today, and we could vote to direct the task force chair, whoever that is, to contact the Ethics Commission if that's what we decide to do at the end of tonight.
okay, all right.
Okay.
I saw Member Johnson and then Member Snyder.
Just a suggestion, the last special meeting I had suggested we go section by section, but we got sidetracked by the memo, and I suggest that we go section by section through the actual, start with the actual regulations, because their legal memo, we can't really force them to change that, but we can say we disagree with their legal opinion. But I think we should start very similar to the way Mr. Grossman has done it. Start at preamble, then the next section, so that we get through the actual regulations instead of arguing about their legal analysis, which we can disagree with but can't really ask them to change.
Actually,
Yes.
my view, I think, is in the memo. I really think that what's going to happen is that over time, they're going to just basically be dealing with referrals. Because if anything like what they have in the proposed regulations now for complaints that are filed with them comes to pass, I would be very surprised that anybody would follow the first one, because they make it so difficult and really quite inappropriate from any number of aspects, that eventually what will happen is what will happen, has happened, which is the only time they have an open government case is when when the task force sends it over. And that's why my suggestion was that we focus on the sections that deal with the referrals. There's also a serious question, as I noted, whether they can either take these so-called garden variety complaints. I think that they're the regs were drawn by St. Croix and Moe, and both of them are neither of them are lawyers, and neither of them are very thoughtful, and neither of them are very articulate. And so what you get is this kind of mishmash of stuff, which they borrowed from the regulations they have governing ethical laws, campaign finance, and so forth, and they try to move as much of it as they could into this set, where they just don't fit. For, as you know, as I've spent tons of time on this, and I'm sure you're sick of seeing my memos, but in fact, that's a big issue, and it's one that they'll have to confront right on, because I've raised it with Harriman, and I'm going to raise it again before the commission in any way I can. And I think it's, I don't know how many of you have appeared before the commission. I know I have, and Rick has, but I don't know if you three have. Hope you have, right? But it's a totally different setup than the task force. They have 5 commissioners, 4 of whom are lawyers, and they have a huge staff. So they're pretty well handling just stuff that the staff sends them, in a way. And what the staff likes to do is to control the process. And the hostility that the staff has to open government, I mean, it's pretty well known. So what you have to do when you talk to them, as we did when Rick and I and the others were there in July, I think, or June, was to make them aware of the fact that this thing is not a slam dunk from their point of view. They have to really think it through. And that's why they junked the first proposals, and they came up with a second kind of set, which we then forced them to think through and agree that even if they accepted the 3 of them, they would reconsider them once they got the task force comments. So I've thought that the best way to deal with it is substantively, because that's what they're focusing on. They're not going to focus on section by section, which is a tedious process. They don't have the time, and they're just going to have these decision points. You know, they got 7 of them in this bunch, and they're gonna get, each section is gonna be handed to them. Do we take it or we don't take it? So what we have to do is undermine their willingness to accept them in total, you know, each of those sections. And that's why my comments are mainly directed to the referrals, because they're spread out, and because I have some serious questions about whether the provisions that they have on simple complaints are even, whether they even have jurisdiction. And I think they actually have that question in their own minds. So that's the way I would go about it. I certainly agree that there should be, if we can get a joint meeting with them to talk about it, it would be good. And I do think that getting over St. Croix and Mo's clear bias against open government is a big task. Because when I met with Harriman and I started to complain about him, she said, I don't want to hear about it. You know, I don't want to hear about it.
Member Johnson, I skipped over you, sorry. I'm sorry, Member Snyder.
I was just going to say, I think that as a preliminary note, it's probably a really good idea to send them a letter, as soon as possible, to buy us some more time to work through this. This has already been suggested, and I just wanted to emphasize that I think that's a great idea, because this is fairly complicated, and I've had somewhat of a chance to weed my way through a lot of this stuff, but it's just going to take a little bit of time. And in St. Croix's memo, he says that the Commission will not consider the draft proposals until after the task force has had a chance to discuss or take action on them. And had a chance is all he said, to discuss or take action on them. So I think it's a good idea to say, look, this is a complex and important issue. We'd like to invite the Ethics Commission to have a joint meeting with I don't know whether it would be this committee or the task force.
I think with this committee, yeah.
Okay. And I don't know if we want to say, postpone a decision. Here are the reasons you should postpone any decision on this until at least after your November meeting, or whether we frame it as a request. I'll leave that to the members who know the Ethics Commission better than I do, whether you want to frame it as a kind of a demand or as a request. I don't know which is more effective, but I think the letter itself is a great idea.
Well, we would have to, I think we would have to frame it as a request. Certainly, we don't have any dictatorial power over the Ethics Commission. However, we can request and recommend that the that the decision, that any action or decision be delayed. We could even say until after the first of the year.
Sir, do they have any reason that they need to do it right away? I mean, do they have any solid basis to say, well, we got to do this now?
I think if we did a couple of things, we could probably convince them without too much trouble that we need more time. But Eileen Hansen is going to vote with whatever we want. That I can tell you, because she's been the only real supporter of sunshine on the commission in the few instances where it's been important. She's voted with on these decision points pretty much with what the public advocates were saying. But what's interesting on the third decision point, which came up, the new commissioner, whose name is Ben Hur, who's a lawyer, and he's with the same law firm as Harriman, he voted against the decision point. In other words, that was passed 3-2 with Hansen and Hur saying, we don't think that we should have that as one of the decision points. And in his, if you listen to the audio, you would hear him towards the end of that discussion talk about, well, do we really have jurisdiction over these simple complaints, or do we really want to get involved in relitigating these referrals? I mean, he was making all the right noises, and he's a very smart fellow. He's Harvard Law School, and he wouldn't be in that law firm doing what he's doing if he weren't very sharp. So my thought was that maybe, and I had a bunch of additional thoughts, either in addition to or as an alternative to a joint meeting, that we get a couple of us to meet with Harriman and her, which is not an official meeting because it's less than, right, Rick? Less than a majority of the.
Well,
Is that kosher to do?
I think they would have to constitute it somehow, maybe form an ad hoc committee or something like that. Otherwise, if they don't, there could be some kind of interpretation of seriatim or something like that.
Well, there would be no seriatim because we're not going to meet with anybody else, but if
you would have to,
a
you would
couple
have
of
to,
us met with them.
you'd have to at least be cognizant of the fact that if two of members of this task force met with them and then relayed the discussions to the whole task force in a way that sort of led to some sort of decision, then that could be seen as a serial meeting.
Yeah,
So you just have to be careful about how you do that.
Then, I don't know. I haven't talked to Harriman since I last met with her, but it's possible that I could call her and ask her if she would spend some more time reviewing this stuff. And something relates to that, which is, I don't know, Dave, how you feel about it, but this thing is so poorly drafted that I can't believe that the city attorney's office ever looked at it. And this is pretty important stuff, and I would think that they should at least vet it as to form, if nothing else, as to consistency, because there's so many ambiguities between a hearing on a referral case and a hearing on a plain complaint case. That's the most obvious. Anyway, I'm willing to do it any way you want. I mean, I've spent enough time with it so that you can go about it. I mean, my views are on record.
Okay, I've just been listening kind of carefully to suggestions and thinking ahead. It sounds like we have some allies on the Ethics Commission. So if maybe one or two, so a joint meeting where we'll outnumber them could be a good thing.
Yeah.
But I think that it makes sense to ask for an extension until the first of the year, but to also propose a joint meeting,
At least one.
at least one before the end of the year. Maybe towards the end of November, early December. That's too late with them?
Well, toward the end of November, we
Oh,
have
that's
Thanksgiving holiday.
Well, maybe mid-November.
Their next meeting is November 8, I think. So their meeting after that would be in December.
I mean, a joint meeting with
The
us.
joint meeting.
Yeah.
Okay, could be sometime in November.
Right, so sometime in November when
Yeah.
it's,
No, I would think that, Ward, at the joint meeting, the last one, I thought that Ward was very into it, and I'm sure Hanson would be. And I think also for better or for worse, these 5 commissioners have never seen or heard an open government case, because if you understand the procedure that was followed, it was the one that they used, as I mentioned, for these other types of violations, which meant that when the task force referred something to the Ethics Commission, they treated it as an initial complaint. So Mr. St. Croix and his crew went out and investigated, and they put together a report, which they claimed was confidential. And under the rules, he could make a recommendation of dismissal, or that there's probable cause, or I forgot the other alternative. And in every case, he recommended dismissal. That was 14 cases, consecutive cases. And the only way that it could be heard then would be if two of the commissioners, within 5 days of receipt of that report, said they wanted it calendared for the next meeting. And Eileen told me that she would ask that it be calendared, and she was the only one. And so the net result was they never actually heard or saw one of these cases, so they had no idea what we were talking about when we would get up there and complain about the fact that they had dismissed all these cases. They didn't really understand it until June, when Chemo and I think you were there, Rick, and maybe Peter Warfield or Chafee, when we started explaining to them what the whole thing was about. And that's when they dumped that first set of proposals, and to repeat myself. And eventually now they have a much better understanding of the framework, the legal framework, because they were sitting at the last meeting scratching their heads, well, how does this enforcement thing work? And how does this willful violation thing work? And how does this other provision work? And they were struggling to figure out just what kinds of cases they could hear and how they should hear them. So I think that their awareness and their ability now to relate to what we're doing is much higher than it was months ago.
Good, okay.
Chair Washburn.
Yes, Member
I think
Johnson.
I would really appreciate it if we could just at least take some of the time, and even if we follow the memo and put our suggestions down, if we could get started doing that, because I think that one of the real problems, I'm not blaming anybody, but one of the real problems we're having is we can't get a quorum when we have the ethics, when we go to discuss these, and we have a quorum here. So I'm not even sure how far apart we are on whether we agree or not, because we've barely had any substantive discussion about it. And it's nice that we asked the Ethics Commission, but the reality is they're going to, one of the things that, and you can see it in their memo, they're very aggravated by our criticisms of them that they don't do something like this, and now we're asking them to push it back. And partially it's because we can't get a quorum of our own task force to discuss this. So if we could at least do something so we could see how far apart or whether we can even come to an agreement, because this is one of the first times we've had a quorum.
I agree. I think this is an opportunity to get some work done. Member Nee?
Yeah, I certainly agree with what Member Johnson has said. And in the meantime, if there is consensus for it, I will draft a letter as chair of the task force to the Ethics Commission and explain to them, you know, ask them to stretch the process a bit and explain to them why we as a task force need to make that request.
Rick, I think if you are going to do that, it would be helpful if you explained what's happened so far, namely that there have been meetings of the task force which have gone till 9:30 or 10, 5 hours long, to handle the normal work of the commission, of the task force, and
Right.
by that time you would lose a quorum, so you really couldn't take up this. Secondly, that you don't, until Dave came on board, you didn't have a lawyer during the period that Erica left, and Dave came on, and he's new, and he's just learning. Well, I wouldn't peddle it. I would just say, you have 4 lawyers on your committee.
He's a little
We've
slow too. Yes.
What?
I said, and he's a little slow too.
Yeah, plus
Just tell him that.
plus he's a little slow,
Right.
And that because it's all essentially legal stuff, it takes the lawyer, your capability is more limited to get it done quickly. The other thing in the letter, I would say that we think another joint meeting would be extremely helpful once they have our comments. That's my view. Because they're going to get them, and they're going to take them up as part of their review of these decision points, and the only voices that will be supporting the task force comments, assuming that one or two of the commissioners don't buy right into them, will be the public, you know, and we only get 3 minutes, or more sometimes, which in fact they gave us a lot more once.
Well, without objection from the members, Member Nee, would you draft a letter taking into
I'd be happy to do that.
consideration Mr. Grossman's comments?
I'd be happy to do that.
All right. I wanted to suggest see how the members feel about looking at the series of threshold questions in Mr. Grossman's most recent memorandum. Does it make sense to look at these substantive issues that sort of overlay the whole, you know, policy, rather than going section by section? Does that make, I mean, we can go section by section, but maybe these broad issues need to be considered. Member Johnson?
Well, some of the things, the broad issues are that we get caught up in these long discussions like now, and there's some really simple things that we could at least address. Like, for example, Mr. Grossman has a list of definitions, which are really key. They bust us on not having a definition in one of the propositions. So these definitions are really important. And he makes some great suggestions. I have one to add on the complaint, which would be excellent if we could have Mr. Grossman here with Mr. Snyder, Member Snyder at the same time, so we can talk about them. And those broad overreaching issues, you know, would come up as you're making the discussions of these very specific, so that they don't just ramble and go nowhere. They're very specific, associated with the sections. Otherwise, they're just everyone's opinion.
Mr. Grossman?
Yeah, picking up on what Hope said, I think the definitions are the best proof that they don't know what they're talking about.
Okay.
Because they don't even describe what an order of determination is. You know, they talk about as a final recommendation concerning a violation. It is not.
No.
You know, so either this is an intentional, you know, way of avoiding having to deal with it as a true enforcement issue, or it's just misunderstanding or lack of understanding or poor drafting. And it could be the last two. I'm firmly convinced that Mr. Moe, who is a lawyer but never passed the bar, did this. And he can't write very well. And as a result, you get all this confusion and lack of thinking things through.
I'm sorry.
That's all I'm saying.
Member Johnson?
I would be curious what the other committee members think of Mr. Grossman specifically. Did you get an opportunity to read these definitions? And then, in addition, under the definitions 2D, where it says complaint, it says complaint means a written document alleging a violation of the Sunshine Ordinance filed with the Commission. I really feel that we should say filed with the Commission or the Sunshine Ordinance Task Force.
Okay, why don't we tackle the definitions now? They're so foundational to this whole document and to the matter at hand. And let's work through these, and if we have to come back and revisit them, if we start rethinking the general principles, so be it. But let's.
What I would suggest, Hope, is if you have word changes you think that are really important, we can talk about them, you know, either on the phone or through email, and I'd be happy to write them up if that would be.
What are we, I mean, maybe I'm confused about what we're,
Well, I mean, this is an ongoing process. I mean, Rick's going to write his letter, but the definitions are critical, as you say, and as I know from having done this for a long, long time, they control the rest of the text.
Sure.
And
well, aren't we going to talk about them?
Why don't we talk
As a-
about them now as a whole group? Member Nee?
I'd like first to go briefly through the preamble, because there is something in there that kind of bothers me. I certainly agree that we need to go through the definitions. There are some things in there as well that I think need serious discussion. But in the second sentence of the preamble, these regulations shall apply only to complaints alleging violations of the Sunshine Ordinance Task Force and referrals from the Sunshine Ordinance Task Force. They're saying that the complaints and the referrals are separate animals. Are they? Should it not say instead, these regulations shall apply only to complaints alleging violations of the Sunshine Ordinance, including referrals from the Sunshine Ordinance Task Force?
Right.
see, that's the very problem that we're talking about.
Yeah.
Referrals are of orders. Orders have been issued, findings made, they have the force of a judge's decree, in a sense. And they go to the department head or whoever it is, and he or the department don't comply. They go to ethics for enforcement. They're no longer violations, issues. The only issue is how to enforce the order. Because if you had it at the task force, you wouldn't treat it as a violation anymore. You would treat it as, why aren't you complying? And if you don't, we have the power to penalize you. We have the power to send you, to San Quentin, whatever it is. So I think just leaving this pretty much as is would be better. Actually, as I noted before, there's this issue about whether complaints alleging violations are subject to the jurisdiction of the Ethics Commission. But I decided I could spend, as I did when I first saw these, I started to go through every sentence and make my changes. I gave up because I knew I didn't have enough time and it would drive everybody else crazy. So I would just focus on the important stuff where it's clear that it doesn't work and it needs to be fixed. And I think that's the best way to approach it with the commissioners, is they're not going to want to wordsmith it. Although the definitions are important. I mean, I wouldn't underestimate that.
Are
Member
you, so
Johnson.
are you saying that there's a no, that you don't want to discuss any of, I'm confused by what you want to do. Because there are certain things in here, like under section 3B, it talks about the executive director, about a referral from the task force. You're scheduling a hearing at the next regular meeting, provided that the executive director give 15 days notice. Well, that means he could just keep not giving it. So it really should say required. We should require him to give 15 days notice. So there are words in here that we need to address, I think. There's a place in here where they talk about failure to appear. A respondent who fails to appear may be deemed to have admitted the violation. Do we want it to say may? Are we not addressing those things here now? Or
I'm sorry, Hope.
I was just trying to figure out how you wanted to go about doing this, if you don't want to speak to specific
Okay.
language.
Well, let me tell you how I looked at it. Because I think the likelihood of their getting direct complaints on simple violations is very, very remote. And they've got 7 referrals right now sitting and waiting. It's pretty obvious that the focus should initially be on the task force referrals, because if we can get what we want out of those, then we can hammer them on the reasons why Section 3 and 4, which relate to simple complaints, are inappropriate or improper, because for a lot of reasons that we could go into. But I really think that, I mean, that's why I did the memo the way I did. I mean, I was really just focusing on the stuff that's critical from the point of view of the referral, because what we want is, when we send it over, we want a hearing scheduled, the nature of the hearing, and the remedies if they enforce the order. And and it should be done in a short time frame, because the complainant has already gone through the entire process before the task force.
Member Nee.
Yeah, I certainly, without prejudice to what the previous two speakers have said, Member Johnson and Mr. Grossman, I certainly want to discuss those things, but I think at the same time, it's a good idea if we kind of take this in some kind of order.
Right.
And I would recommend that we, obviously there is not consensus for what the fix that for the issue that I raised in the preamble, so I would recommend we go through the definitions now.
Okay. All right. Members, do you have specific changes you'd like to see? Member Nee?
A few things. First of all, in definition D as in David, complaint means a printed or electronic document alleging a violation of the Sunshine Ordinance filed with the Commission. In definition G, deliver, I would strike the word, in the third line, I would strike the word delivery after including, and I would say including but not limited to email or fax. In K, order of determination, I would strike the words final recommendation issued by, and I would say order of determination means a finding by the task force of a violation of the Sunshine Ordinance and prescribed remedy or remedies. Um, 12 in L, referral means it says a reference, and I think that should be referral. Also, I would say referral means a referral for enforcement and or penalties from the task force to the commission for non-compliance with an order of determination. I guess we could say a referral means a referral by the task force for enforcement or penalties. No, the task force is in there. A referral means a referral for enforcement and or penalties from the task force to the commission for non-compliance with an order of determination. In M, just a couple of copy editing things. I would cross out, in the first line, I would cross out the words who is, and in the words, in the second line, committed a violation of, replace those 4 words with the one word violated. So it would read, respondent means a person alleged or identified in a complaint to have violated the Sunshine Ordinance. That's what I have in definitions.
Member Johnson?
It seems as though the D complaint shouldn't just be identified as a complaint filed with the commission, but also with the commission or the Sunshine Ordinance Task Force. For example, you know, if you don't define it that way, in definition M, it says respondent means a person who is alleged or identified in a complaint. Well, that's already wrong, because that complaint refers to a complaint for the Sunshine Ordinance Task Force. So throughout, complaint has been consistently undefined, even in our own proposition, which later on. So I think if you don't add complaint means or the Sunshine Ordinance Task Force, some of these definitions later on are going to be vague. And I think that that we need to take that into consideration, because that makes that definition M in a complaint to have committed a violation of the Sunshine Ordinance. Well, the referral, they're referring to our complaints, even though they define complaint as only with Ethics Commission.
Okay.
So in the definition of respondent, you wouldn't use the person or agency head or official who has not complied with the order?
No, I would add to definition, I would leave M the same as you, similar to what you and Chair Nee had said, but in definition D, it says a complaint is just a document alleging a violation filed with the commission. I would add to that sentence, filed with the commission or the Sunshine Ordinance Task Force. Because later on in M, that definition, that word complaint is now defined in a really oddball manner for that whole definition. And there's other places, I mean, it's too long to go through it, but there are other places where they sort of offhandedly referred to complaint. And in the very end of, in here and in their memo, they're one of the ways that they're getting around open government is because in Prop G we didn't define complaint, and it's never been defined, and this is the only place that it is defined. So I would throw in the Sunshine Ordinance Task Force there.
Okay.
Well, I think, you know, when everybody has their whack at it, you know, we can vote on it.
Okay. So, Member Snyder?
Just a quick comment. I have really only one thing on the definitions. I would just agree really with both Member Nee and Mr. Grossman's, although your edits are different. Your edits on K, order of determination, this is the one thing out of all these that I think is very important. Their definition of order of determination includes the word recommendation, which I think is absolutely critical, and I don't think that can or should be in there, because what this sets up is that the task force is only recommending some course of action. And so you had one solution, Member Nee, and you had another solution, Mr. Grossman, but both of your solutions got rid of the word recommendation. And if there's one thing that we do with the definitions, I think that's the most important thing to do, is get rid of that word. You see what I'm saying?
Right. Both recommendations for K have the word finding.
Yeah, finding is...
which is an important word here.
Yeah, I think finding is fine,
Yeah.
because courts make findings, and finding has a sense of finality about it.
Right.
And they do say it so that their draft, of they being the ethics, whoever St. Croix's definition, does say final recommendation, but it's still just a recommendation
Yeah.
in their view, and that's wrong.
It's actually not a recommendation.
No,
That's what I'm saying.
that's not what it is.
It's an order directing somebody to do something.
Yeah, that's what I'm saying. So we, whatever we do with these definitions, that word recommendation can't be there, or shouldn't be there.
And Member Nee's wording has prescribed remedy or remedies to indicate that we're ordering something to be done, prescribing it. Are there other suggestions for changes in wording of the definitions?
Member
Nee?
Yeah, under K, instead of prescription or prescribed remedy, I would say Order of determination means a finding by the task force of a violation of the Sunshine Ordinance and instruction for remedy.
Are you talking about L or K?
Okay.
Does instruction have the same heft to it as prescribed, though? Prescription,
I would say it's stronger.
stronger.
Maybe a remedy is maybe an odd choice there, because remedy, in a court of law, a remedy is it's like damage. It can be damages that a plaintiff receives, and I think what we're describing there is not a remedy exactly, but a penalty, right?
Well, corrective action. In other
Yeah.
words, the order of determination is issued to the complainant and the respondent.
Right.
And we could say instruction to the respondent for corrective action.
Oh, okay.
Yeah, I think that's probably a better phrase.
How does that work for you, Mr. Grossman?
I missed that, I'm sorry.
Okay. In K, order of determination means a finding.
No, it's not a finding, it's an actual order, and on the thing it says order of determination. When it goes to
What is it you
whoever it
just
Okay,
goes
can I-
to.
can I- let me-
It's not what it does is, I'm sorry if I'm getting excited, but the whole point of this is to look at this as a final action by the task force. It can't be relitigated. It can't be undermined by somebody saying, well, I didn't understand it, or I forgot to mention this or that. It's gone out. You've held a hearing on compliance. There's been no compliance. Any questions that person had could easily have been answered. Then it goes back to the full task force, and there's another hearing, and then it goes to ethics. So there's no issue about what it means. It's an order of determination that there's been a violation of a particular section or sections of the ordinance, or even I think of the CPRA on occasion, and the fact is that the individual has not complied with it, period.
Well,
And there's no more to be said about it, because the last thing in the world you want them to do is to say, I think that when he testified, 3 months ago, they misunderstood what he was saying. You don't want that. And they don't want it.
well, we've stricken the word recommendation, and if I can, let me just finish what I wanted to say. Order of determination means a finding by the task force of a violation of the Sunshine Ordinance and instruction to the respondent for corrective action.
What's the opposition to Mr. Grossman's definition, that it means an order?
The only thing about that, I see Mr. Grossman's point, and finding does have so trial courts make findings which appeals courts can then reverse, but it does have, finding has something of finality about it. The problem with order is that it's a bit circular. Order of determination means an order. It doesn't really tell you very much. Maybe we could say a final order. Throwing the word final in front of
Well,
it.
I don't think that makes any difference, personally, because we don't call it a final order.
Well, what we could say is a verdict by the task force finding a violation.
It is what it is. It's an order of determination. That's what it's been called forever. And it's called that in the ordinance.
But if the goal is to describe it in a way such that the Ethics Commission understands that this is a final decision, I'm not sure order gets us there just because it's somewhat circular.
It repeats. You're already saying order here. Why do we need to repeat the word?
You're saying it's an order of determination. An order
Order of
is
determination
an
means.
order issued by the task force to a respondent filing. We could say pursuant to.
I think the most important thing is definitely we get rid of the word recommendation, but I'm not sure it matters all that much whether it's order or final finding or verdict. I do take your point, Mr. Grossman, about finding by itself. That may be a little bit too
It says,
temporary sounding.
Upon determination that the record is public, the Sunshine Task Force shall immediately order the custodian to comply with the person's request.
Yeah.
Oh,
It's an
Mr.
order.
Grossman, microphone.
If the custodian
I-
refuses or
microphone.
fails to comply with any such order,
It's
We
not
could-
really a dictionary definition. It's a legal definition, and
Sure.
it's an order.
Sure.
we could
Well-
call it black cat. If it's a definition, you can call it anything you want.
But, yeah, I mean, and I take your point too, it's not a dictionary definition, but if the goal is to create an understanding legally or otherwise of what the finality of this action is,
It's not final.
well, but
I mean,
what
that's
we're
for
trying, it's not final, but but I think what we're trying to do here is not allow the Ethics Commission to create a situation where the Sunshine Task Force is merely a kind of recommending body to the Ethics Commission. And so,
It is a recommending body.
but is that all? And they can rehear anything that they want? I mean, they can start over, hear it anew, and decide the issue from scratch?
That's precisely what
What
they've
is
been
it if
doing.
it's not a final order?
Yeah,
Hope?
that's,
It's an order, but, I mean, part of the reason recommendation came in there is that we even use those words. We refer it to the Ethics Commission for review.
No,
which
we
means-
don't. We refer it to them for
Well,
enforcement.
for enforcement, but their
Yeah,
version.
but what makes it not final as far as the task force is concerned? Once it's out of its hands, what is it going to do? It's final as far as the task force is concerned.
I
Member
mean,
Nate?
I agree
The
that,
process has gone all the way through from beginning to end, and the last thing that
well,
happened.
trial courts are not, their orders are not final, because they get sent to a court of appeal. There's plenty, I mean,
No,
they're
but it-
final, but they're not,
Well,
the word
but
final being
until-
in there isn't going to make the Ethics Commission not say they can't review it.
Well, they're going to review it maybe for some reason other than the fact that there's a finding made by the task force. Either it wasn't sent to the right person or, whatever.
I'll go after him.
But they're not a reviewing body, they're an enforcement body.
Member Nee, then Member Snyder.
Yes, why don't let me suggest some other wording then. Order of determination means a declaration by the task force that a violation of the Sunshine Ordinance that there has been violation of the Sunshine Ordinance and instruction to the respondent for corrective action.
We
I
could
just-
use a determination if you want.
Yeah.
That's what I think is in 6721, what is it, E?
So
Member Snyder?
my point is, I think the task force does recommend, but I think the question is, what is it that they're recommending? I think what St. Croix's view, I'm guessing is his view, because it seems to be the view of this document, is that the task force is recommending what the final decision should be as to whether there was a violation. I think the more proper view is that the task force is recommending a form of punishment for what we have already determined is a violation. It's the Ethics Commission's job to determine what the punishment will be, or what the remedy. Remedy's not the right word, but what the solution will be.
But
They
the more
don't.
words you put into it, I mean, I really like Mr. Grossman's definition of just an order. The
Yeah.
more things that you,
Yeah.
declaration, finding, all of those things are
Yeah.
mildly vague, and attorneys will move them all around, whereas an order encompasses a demand. It's like saying, we're enforcing this. An order has sort of a quality of having a rule about it. But if you put declaration or a lot of other words in there, those allow for greater interpretation.
There's
Member
a-
Nee?
Excuse me, there's actually another aspect to this and it's kind of a subtext to all of it. I would say, I won't say the commissioners, but certainly among the staff, they consider the task force to be inferior in terms of its authority and status within the hierarchy of the city commissions and boards. In other words, they view it as not a charter commission, and therefore it's inferior to a charter commission such as ethics. So you first have to get them past that to recognize that when you do something, it is has the same legal consequences as if they did it, because you're at least at the same level in terms of the hierarchy within the city, boards and commissions. So you have to work very hard to make sure that's the case, because my experience, if you read the stuff St. Croix spits out, he'll say the city attorney has more authority to decide these questions than the task force, because he's elected, if you would believe it. So you got to get past that, and by giving, see, that's where this recommendation stuff comes from, because they don't consider what you do as the equivalent of what they do.
Okay.
And it is. And you have to realize that too.
Okay.
It's important that you do that.
We need to make sure that our wording reflects that, our recommended wording. Member Nee? No? I just wanted to say that I like Mr. Grossman's, and I agree with Member Johnson about using the word order. I think that adding other words might muddy this a little bit. But I also like instructions, the phrase instructions to the respondent for corrective action. That further defines what our order means. We find a violation, we give instructions on how to correct. And
That's
we want
okay. Yeah.
the Ethics Commission to enforce
That's okay.
the order.
I don't know if the
No,
word
you want them to
instructions is
punish
the correct.
them. See, you're saying two things. Do you want them to enforce? Because as the task force, we sometimes would like, they violated it, but what we really want is for the complainant to get what they want. But once it goes to ethics, we want them to be punished for their violation or fined or whatever. Not to.
We want them to be punished for failing to follow the order of determination, not for the violation per se.
Well, that's what the definition of referral says.
Enforcement, yeah, and or penalties. Yeah, okay. So it's in the next definition.
Yeah.
But I like adding the instructions.
Any more suggestions for definitions? At this point, do we want to entertain a motion for accepting our work so far on the definitions and moving on?
So move.
Do I hear a second?
Just a clarification.
Yeah.
And are we then, so is our decision then that we're going to give these as recommendations to be forwarded on ultimately to the Ethics Commission, or what's the decision that we're making here?
Well, once we draft the statement, what we're doing here will be included in that statement
The statement to,
to the Ethics Commission.
And then we can vote on that.
okay. So all the changes that we've discussed here we would make those changes. The motion is that all the changes that we've discussed, including Mr. Grossman's and yours?
Correct. All those on which we've consensed.
Because I think wait. Referral.
But we would get an opportunity to review the recommendation like we did with the letter to the community college board.
So this isn't set in stone for us after this motion. I
Well,
guess
do
we
you
need to
see
clarify
any
that.
need to actually vote on each of these things? Why can't we just construct what we're planning to do and then look at it as a whole and tweak it if we want to and then vote on it?
Okay.
I think that would be, because I didn't get all of the changes that were discussed. And, I mean, I'm not voting, but I'd like to see them. And I think in the long run, it's going to save time, and it'll give you a chance to think about it, you know, when you see it on paper. That would be my suggestion.
So does the maker of the motion want to withdraw the motion and we, without objection, move on to the next section?
If second wishes to withdraw, then I'll withdraw.
Did I second? Sorry.
Was there a second?
No, I
Oh,
don't
you
think there
you
was.
had,
No
what- you
second?
went, no, there wasn't.
Okay, motion is withdrawn. Madam Chair, it's 5 o'clock, which, past 5 o'clock.
Past 5
which
o'clock, and we have members of the,
we should have public comment
Comment.
on the definitions, and then open it to general public comment. But there is nobody in the audience.
all right, there was at 5, sorry, I saw them, but we were in the middle of this. Okay.
Did he leave, the gentleman that was?
There were
There
two
were
gentlemen,
two
yeah.
gentlemen, they both left.
All right, let's move on to the next section, Section 3. Member Johnson?
I had a couple of, I don't know exactly how to remedy them, but a couple of issues. One is that in section 3B, it says that when the executive director receives a referral from the task force, they'll schedule a hearing at the next regular meeting, provided that the executive director issue a written notice to each respondent and give a 15 days advance notice of the hearing date. And rather than it saying provided that, I think it should have some language in there that requires the executive director. Because it seems to me that it is an area where they could keep putting things off intentionally by not providing the 15-day notice.
This is another case of they're not knowing how to draft something. You know, it's not really a condition to the hearing. It simply, it shouldn't be anyway. But if he doesn't give the notice, then they can't have the hearing either.
Oh, that's
So,
crazy.
you know, there's two ways of looking at it. Quite honestly, that didn't bother me particularly, because I think that's what they're trained to do. So I don't distrust them from that kind of almost bureaucratic response to getting a referral. My concern was in A, as I put in my memo, that allows the executive director to handle a complaint even if there's a companion complaint before the task force. It says when the executive director receives a complaint that the task force has not yet considered or that is still pending, the executive director may handle the complaint pursuant to Section 4
Yes.
or may take no action until and so forth. But the fact is, as I noted, if you follow their procedure, they could very well dismiss the complaint after the executive director makes his so-called investigation, and then you decide that there was a violation, you issue an order, it's not complied with, and then you send it over to ethics for enforcement. They say, we've already ruled on that one. So I don't think that that makes any sense to me. And the other thing is, as I noted in the memo, under 4C, the respondent has a right to be represented by counsel at the hearing, which he could not be. I mean, it would have to be the city attorney's office. wouldn't have to be, but in all likelihood it would be. And they can't do that before the task force, but they could before the Ethics Commission.
Well,
Well, where does that get you?
let's just concentrate on 3 now, and I have a lot of problems with 3A too. Do we want to salvage anything from it or strike it all together?
Strike it. I believe Member Wolf suggested we strike that paragraph at our special meeting, actually,
Yeah.
as well.
No, in reviewing the materials for today, I had the same feeling. We should get rid of it altogether. Member Wolf, we're looking at
Which one?
section 3A.
3A.
We've gone through the definitions.
On page 2,
I see it.
2 of the regs, not the memo.
Yep. Yeah, wipe it.
Other members, Member Nee, Member Johnson, your feelings about 3A?
I agree with striking it altogether. I don't know how you would repair that.
Madam
Member
Chair,
Wolf?
I would just say, I mean, if anything, I mean, this all puts it in the hands of the executive director. I mean, you put it in the hands of the commission, it's one thing. But you put it in the hands of a staffer, it's another. I mean, if the executive
Yeah.
director is just the vehicle by which paper is being moved around, that's one thing. If the executive director is the one who's making a decision, as that person frequently does, that position frequently does, then that's my objection to it.
Right.
I mean, perhaps one thing we could do,
Well, can I chime in?
Okay.
This assumes that they can hear garden variety complaints.
Right.
And that's still an issue, at least as far as some of us are concerned. They would be silly, actually, to take those cases because it just clutters their workload up, and the staff is already overworked. They should leave all this stuff to the task force because that's what the law was really intended to do. That's what the ordinance provides for, and or as an alternative to the supervisor of records. And the Ethics Commission should stay out of it. But the decision points that were agreed upon, which will be revisited, included the right to take these complaints.
I'm wondering, and yeah, I agree with you about all the problems with this. Shouldn't we go back to definitions then and change the meaning of complaint so that it isn't something that's filed with the commission, it's something that's filed with the task force?
Well, I think that there are strong policy arguments that should argue for leaving everything in the hands of the task force because they've got the expertise, they've got the procedure in place, and the way in which these hearings are handled, if you look at section, 4, it's pretty scary because first the executive director issues his report, and if he wants to dismiss it, he recommends dismissal, and then they've got this 5 days to get 2 commissioners to get it heard. And we know the history. He's dismissed 14 in a row,
Right.
speciously, I might add, having seen, the records now. So that's one part of it. And then when you get to the hearing, who can appear? For complaints that allege a violation, the parties who have the right are the executive director and the respondent, but not the original complainant.
Okay.
Well, isn't that weird? He's the one that knows when he went to the office and asked for the record and who he spoke to and the whole thing. And no, it says no other live testimony is permitted. Plus, it has to comply with the California Administrative Procedure Act, which I just looked at, and it's 120 pages or something. And God knows whether it even applies or need to apply to this type of hearing. So the gauntlet is huge for the complainant as compared to the task force, which was intended to be a user-friendly, quick resolution, not a formalistic type of hearing where you need a lawyer.
Okay.
So
Member.
my approach would be, guys, you're making a mistake by doing this. Even if you think you have jurisdiction, why bother?
Okay.
Does that mean that you agree with striking it altogether?
Pardon?
Does that mean that you would agree with striking that particular provision altogether?
3A.
Well,
3A?
I would certainly say dumb it down then. You know, if you want to hear these complaints, do what the task force does. You know, let the complainant represent himself, go through the procedure, listen to him, and if you decide that if there's a case there, make your decision. But don't let Mr. St. Croix and that crew handle it, because it'll never get past them. And there shouldn't be this threshold that two commissioners have to, opt for hearing it if the recommendation is dismissal.
Member Wolf?
Yeah, in the past couple of meetings we've talked about this. My interest for wiping this out completely is because it basically redefines and creates a duplicative process of the entire task force. So essentially, the Ethics Commission has a certain level of power and authority already that's much higher. It has the ability to enforce. There would be the supposition by whoever the policymakers are in the period of time to just say, well, why don't we just fold the two in together? We'll disband the Sunshine Task Force and have it all managed by the Ethics Commission. And that's my foresight. That's what I see and predict what will happen in the future. I mean, right now with the supervisors trying to micromanage the way we take minutes, I mean, to me, that's just foreshadowing of what is about to come. So I would say if you want to dumb it down a little bit, I would say in 3A, any person, including commission staff, may file a complaint with the commission or the task force alleging a violation of the Sunshine Ordinance. When the executive director receives a complaint, the executive director shall forward any and all complaints to the task force, period. Okay, in B, same thing. When the executive director receives a referral from the task force, the executive director it's a referral, so that's different.
No, I think that's a good suggestion, but the legal arguments shouldn't be ignored, in a sense. I mean, what we're saying to them is, not only is it the smart thing to do from a policy point of view, but it's probably what was intended, because why was the task force created in the first place if the Ethics Commission could hear these complaints? And the section that they're relying on in the ordinance doesn't talk about complaints. It talks about enforcement of violations.
Right, so who determines what a violation is then?
Well, in the examples that were used are, if the task force finds a violation but does not refer it, but sends it to the district attorney or the AG, the complainant can take it to the Ethics Commission if he wants to, and the supervisor of records has the power to order a compliance, and if that order is not complied with, then the complainant can go.
Can you cite the section of the code that says that? Because I'm not aware that that's available to people.
Okay, I'm not going to argue the legalistics with you about 6735D is the section they're relying on to take jurisdiction of these simple complaints. And it doesn't talk about simple complaints. It talks about enforcement of violations, And they were puzzling that through at the meeting that they held when we were all talking about where does their jurisdiction come from, and I don't think it's settled. So I think if we give them a good reason why they don't have to worry about that, then they may very well say, listen, we'll let the task force do its job, and if it gets to us, it'll be an enforcement matter.
Well, to me, it's a fishing expedition for them to try and find a way to be able to handle complaints.
I don't think so.
I think 35D, from what I recall, is, as you say, specifically to enforcement. It is not for adjudication. It's not for determination of violation. It's not for any of those things. It's very, very limited. In fact, the Ethics Commission is falls within the line of the AG, the DA, and then the Ethics Commission. Okay, and the AG and the DA always say, did you follow the local process first? And if you followed the local process first and you didn't get satisfaction, or they didn't take up the issue, then we'll deal with it. But it's just pure enforcement. It's not, has nothing to do with a complaint.
I know, but what I'm telling you is, having been there and met with Susan Harriman twice,
Yeah.
there's this idea that they can take these cases, simple complaints, on the same form that would be filed with the task force.
understand.
You change the name of the
But
body to the Ethics Committee. So what we have to do, if we don't think it's smart, is not only try to convince them that from a legal point of view, they don't have that jurisdiction, which is the point you were just making, and it doesn't make good policy, which is the point you originally made.
Right.
So, you know, we should all kind of come together on that and make it a very important part of what we're doing. And the fact is that if you read these regulations, the complainant who goes before the Ethics Commission has got an impossible task to win.
Okay, let's see what 67.35 says, Member
Yeah, so
Snyder.
I was just looking at. I mean, I don't think they're not pulling this idea completely out of thin air that they can hear an initial complaint. I mean, it does say that any person may institute proceedings for enforcement and penalties, blah blah blah, before the Ethics Commission. And so, I mean, I know the argument is, well, enforcement means,
After you've determined that there's a violation.
but isn't that what penalties are? I
No,
mean, so that-
penalties are determined as the result of whether enforcement is valid,
Actually, are
Is
you reading
considered.
67?
Yeah, 6735D.
But it also says a court
Right.
for enforcement,
Right.
not just the Ethics Commission.
Right.
So the court is now brought in a different way, because you can file a records case
Yeah.
with the court if you can't get your records, and there the issue is, are you entitled to them? So why is the court again referred to in 6735D? Well, it's for enforcement of an order. Somebody ordered compliance and it didn't happen. And that's
Yeah.
the clear.
Yeah, and then I guess you follow up, you say, if enforcement action is not taken by a city or state official 40 days after a complaint is filed, and that implies
It's also, that's part of Prop G, right? So when you interpret a statute, and I assume the same, because you do administrative codes that way, and I assume a voter code would be the same, you look at the intent of the drafters, the intent of the legislator, or the intent of the voters, which was for enforcement purposes, because the Ethics Commission wasn't enforcing it. And that says that in the voter guide, by the way.
That's an excellent point, that the task force doesn't have enforcement authority. The enforcement authority is handled by a third party.
So what is the situation under which any person themselves, not a referral by the task force, can bring something to the Ethics Commission for enforcement? How would that happen?
Well, you enter an order of determination. It's not complied with. You send it to the AG, and the AG returns it and says it's a local matter. End of case before the task force. So the complainant now has a non-complied with order, and he's got no place to go. Well, what 6735D
Gotcha.
says is,
Yeah.
well, you go to ethics, or you can go to court.
Okay. All right.
That's
I
what
see
it-
that. But
And the supervisor records, if you look at 6721 whatever, they also issue orders, the supervisor of records. May petition the super for a determination whether the record is public. Upon a determination that the record is public, the supervisor shall immediately order the custodian of the public record to comply with the request. If the custodian refuses, it's okay. Then the supervisor notifies the district attorney or the AG, who shall take whatever measures he or she deems necessary. Well, if they decide they don't want to do anything, they've got the complainant has an non-complied with order. What does he do? He goes to ethics or he sues on it. And that's 6735D.
And it was added for that specific purpose. It was
Let-
added later.
Let me add something, a point of clarification to that is that also is part of an administrative process, just an internal flow where an internal supervisor of records is requesting or ordering a custodian of records. We're not even talking about, we're talking about an internal administrative process. We're not talking about you go to, the mayor's office and they say no. Well, there's no internal process. It's done. And then you have to come to the task force because that's your only remedy, or quote unquote remedy. But if a supervisor of records, let's say Department of Technology goes to the SFPUC and tries to get a map of some conduits in the city, PUC says no. Okay? Department of Technology calls the supervisor of records, says, is this information available? Supervisor of records says, yes, it is. They tell them what's going on. Supervisor of records goes to the custodian, and the custodian says, I refuse. See, it's all contained within the city hierarchy at that point. It has not even exited. Nobody has said to the member of the public, it's not even has anything to do with the member of the public at that point.
I'm not sure that's right, Bruce, because anybody can petition the supervisor of records. I've done it.
No, I understand. I'm just giving you an example
Okay, but it's an external, it's external to city government, except that the supervisor of records is anointed
Right.
under the law with this special position.
Right.
And the supervisor of records is the city attorney.
Right.
And so if the city attorney determines that a record is public and tells an official or a department head, you disclose it, and they don't, why should a complainant have to do anything more, than
Right.
go to court or go to ethics?
That's right. That's right, just because they've already determined that it's a violation. It's done, they've done the job for us,
Okay.
more or less.
I'm wondering, for 3A, to move the process along, we had some language dumbing this down that sounded pretty reasonable. Has that been captured?
In 3?
Right,
3A?
can I hear that again?
Yeah, I just said in 3A, any person, including commission staff, may file a complaint with the commission or the task force alleging a violation of the Sunshine Ordinance. It's just an intake at that point. When the executive director, supposedly executive director of the commission, receives a complaint, the executive director shall forward any and all complaints to the task force. So you've got two ways for a complaint to come in, either through Chris's office or through 25 Van Ness. Either way, however it gets processed, it comes here.
Okay, so-
It ends up in Chris's hands.
So the second sentence, would you read that again? When the executive director
know,
receives a
it-
complaint?
When the executive director receives a complaint, the executive director shall forward any and all complaints to the task force.
Well, that is kind of a practical way of dealing with this ambiguity.
Mhm.
The real doctrinaire way would be not to have that in at all. But,
I know.
okay,
I'm just saying
I'm
that,
just saying, it's a diplomatic out.
I
You know,
agree with you.
We
and
could
I was-
give them, we could say, look, our preference, get rid of the whole paragraph.
Right.
If you really feel wedded to having the paragraph there, this is what it should say, and then we could explain why. Because
If you knew them, you would not offer them a
6735D doesn't authorize this. you're not authorized to do this, and so either you should get rid of the paragraph or you should phrase it this way.
Well, part of the problem is that if we don't get it out of there, I mean, either the way Bruce suggests or by demonstrating they don't have the jurisdiction in the first place, then the complainant is either stuck in their process, and I would think he wouldn't want to be, he or she would not want to be, and so would come to his senses and withdraw it. Or if he does get stuck in the process, then it's going to be almost insurmountable to the average person, because you've heard these folks that come up before you on these complaints. You know, the Administrative Procedures Act. I mean, the whole thing is otherworldly in my view, in terms of handling it as a formal proceeding, where the executive director is the prosecutor, I might add, because the complainant can't even speak at the hearing.
Okay. The next paragraph, 3B, do we have some changes?
I just want to finalize 3A by just saying, I would start out by saying, strike it, and then let them come back and say, well, you know, where's the middle ground on this, and then offer them the language.
And we could also, in striking it, it might be a good idea to offer briefly why and say,
Yeah.
this is not authorized by the ordinance.
Yeah.
You can't do that, and here's why, blah, blah, blah.
Yeah, I agree. I mean, that would definitely, they would probably expect or ask that question of us.
Yeah.
But yeah, I would definitely agree to back it up, give it some background.
Yeah. And one of the things that, Bruce, I had mentioned earlier before you got here, is these commissioners haven't spent any real time trying to understand open government cases and the Sunshine Ordinance and the relationship of the task force and the supervisor of records and the ethics commission in the whole process and how the process unfolds before the task force. Because if they did, they would realize this is nonsense.
Yeah.
This is plain and simple nonsense.
Okay, so do we have a consensus that we'll strike it and then with our reasoning for doing so? And then if we get a lot of pushback, we have this dumbed-down version? Okay. All right, moving on to 3B.
Another procedural question. I don't mean to keep coming back to this, but when I asked earlier, I was trying to figure out, we had a motion, and I was trying to figure out what the motion was so that we could make a decision about what it was we were doing. And I think we decided that we're going to come back and do a motion at the end with all of the edits
Right.
and changes we've. I'm just concerned that we have memorialized somewhere central all of these edits and so forth that we're making, and that there's some kind of a document after we're done here that we can say, well, okay. But
So Chris, you're capturing all of this and this is being recorded and so, yeah, okay.
I mean,
all right.
so one option would be to, after each section, when we get through it, we just memorialize this in a motion and say, here are the changes we made and here's what we're going to do.
Well, we're not
Is that
voting
too
on the
cumbersome?
motion at the end of today. We're voting on a motion after it's been memorialized. That's what Mr. Grossman was
Okay.
saying, that he can't recall every single thing we discussed. So it's not at the end of today, it's after it's been memorialized, written in a written form
Okay.
at a later time.
All right.
So we're doing something kind of similar, but not in terms of motions. We're using a consensus process to move through this.
Okay.
So 3B.
I know
Member
that
Johnson.
Mr. Grossman didn't mind that much about provided that, but, so we don't have to go into a lot of detail, but I worked at Heller Urban for 7 years. I went to Bolt Law School. I worked at AT&T, and my only job was to respond to discovery and write demurs, and I would seize upon that immediately, because provided that means that executive director has complete and total control over whether or not a hearing gets scheduled, and I think it's a huge mistake.
You talked me into it, Tope.
Yeah, I agree with you
Okay.
too. I would just say the executive director. The executive director shall schedule a hearing at the next regular meeting of the commission. Strike the words provided that and the numeral 1 and replace it with and. And the executive director shall issue a written notice to each respondent and the original complainant of the date, time, and location of the hearing, blah, blah, blah. So that way he's required
fine. That's
to
fine.
schedule a hearing, and he's required to give notice as part of that.
Sold.
All right.
Okay. We have a consensus on 3B. Great work.
Provided that section 5 is to our satisfaction.
3C, member new.
Yeah, just one on 3B, one copy editing suggestion. Scratch the first 5 words, when the executive director receives, and put upon receiving a referral.
Okay.
The executive director is already,
Right.
in the subsequent, and also after the word "and," cross out the words "the executive director." The executive director is already identified. So, upon receiving a referral from the task force, the executive director shall schedule a hearing at the next regular meeting of the commission and shall issue a written notice
Yeah.
to each respondent, et cetera.
Sure.
Nice, okay.
Are you sure you want to do that? I mean, on receiving leaves it open to received by whom?
No, it
No,
says
it's the
upon
executive
receiving,
director.
comma, the executive director shall.
That does not indicate that it's the executive director that receives it.
Yes, it
You-
does.
you know, the-
Grammatically, it does.
Without wanting to throw a monkey wrench in this, if they get the referral within 15 days of the meeting, then they can't take it up at that meeting because the notice is 15 days ahead of the meeting. So, I mean, I wouldn't struggle with it here, but it means you have to make sure that the full 15 days exists when the referral comes in. Otherwise, it won't comply with the section, and there's no other provision to deal with it. So it should be wordsmithed in a way that 15 days, and why should it be 15 days? Maybe it should be 20 or 30. I don't know. I think it's important.
Member Wolf?
It's just a comment.
You know, one of the major things that bothers me about this whole document is the authority that's given to the executive director ex parte of the commission. And I think it needs to, everywhere it says executive director, it should just say commissioner, commission. Because the executive director is an element, a component of the commission, much in the same way our director is a component of the task force. And nowhere necessarily in the Sunshine Ordinance does it specify that the director of the Sunshine Task Force does this or that. It's the task force and its office, et al. So I think that is a much more appropriate way, because the executive director, nowhere, I don't believe anywhere else, maybe in the Planning Commission, but I think it's referred to as the Planning Department, because the commission is the oversight for the Planning Department. In the ethics, it's not, the executive director is the executive director of the commission. It's not an ethics department.
Well, he in fact is, I think the charter says he has the role of a department head.
But the question is whether the commission oversees a department. I would much rather see the Ethics Commission be regarded more like how we're set up with regards to these particular regulations that they're creating. Anything else that they do, fine. But these are internal to them. This is not amending laws. It's not going on the ballot or anything like that. These are written in a way to provide specific authority to the executive director as a matter of internal policy. And I think and the executive director is the one that's writing this and then suggesting it to the commission. So I think that that's inappropriate, especially when it dovetails with what we do. So I think that it should say that it's the commission. Now, if the commission wants to, hand off duties to the executive director, it can do so and does so in many different ways. It doesn't have to be in this format. I think the executive director should be stricken from the definitions and should be stricken from the entire document and replaced with the word commission, meaning ethics commission.
I agree.
You're convincing.
I mean, you are convincing. I would, in my view, that's arguably unnecessarily confrontational, and what they're going to do is just read executive director into it anyway. And so we're saying, we don't like you, executive director, John St. Croix, and we want to get rid of you from these ordinances. And then what the commission does is it just reads it in anyway, because the commission itself can't, there's a bunch of functions in here that they delegate to the executive director, that the ordinance delegates to the commission itself really can't undertake. And so they would just impliedly say, all right, well, everywhere it says commission, it means executive director. It's a semantic difference that I agree with you in substance, but I think it's a semantic difference that ends up being sort of more pugnacious than we need to be, and that it sort of just rattles a saber that we don't necessarily need to rattle, and I'm not sure it's going to actually make that much of a substantive difference.
I've been a martial artist since I was 9.
If you make the executive director simply a paper pusher,
Right,
then you've really accomplished your objective.
right. Well, that's right. That's a way of doing it. All I'm saying is that I think it's important that we, as the task force, if we feel that the document is overbearing and that that we do make all our decisions as a body. We don't necessarily allow anybody that works for the task force to make decisions autocratically. They can make decisions autonomously that are based upon what has already set up in the ordinance and that what we deemed for that office to be providing. That's one thing. But here, this is redefining like a whole authority that the commission is supposed to be involved in. And if it's supposed to outline, like, this is the process by which way an enforcement of a referral gets processed, okay, that's one thing. But my concern is this is not about John St. Croix. This is about the person that comes after John St. Croix.
No, I hear you.
And the person that comes after that person.
Another way to highlight this concern such that the commission understands that we're worried about it and why we're worried about it is to include, when we give them our broad suggestions and then maybe even our line-by-line edits about how we think this should be changed, we include in that sort of preamble the idea that, look, any power the executive director has is delegated from you. And one of our overarching concerns with this, it's not.
Section 15101 says the executive director shall be the chief executive of the department and shall have all the powers provided for department heads. Subject to the civil service provisions of this charter, the executive director shall have the power to appoint and remove other employees of the commission. And he does have department head powers.
Well,
So
Chris would have the same authority.
It
No,
doesn't, it doesn't make any difference if in this case, in the cases of referrals or complaints, and we don't want them to handle complaints, Mr. St. Croix or his successor is simply acting as a middleman, handing papers to parties.
The commission shall appoint and may remove an executive director. He's acting at the commission's behest, is the only point I'm trying to make. And
But they're not going to remove St. Croix at all.
I'm not
because they love
suggesting
him,
that.
but-
I agree with what you're suggesting, but the reasoning was starting to differ from the charter. That's all. That's the only reason why I read that. I agree with taking the executive director out. I agree that it should read the commission in here. But if you're going to include reasoning as to why, if you start to drift from what that charter says, he does have department heads. They'll use that back. That's all.
Well, the thing is, you're dealing in two different arenas. You've got the referral arena and you've got the simple complaint arena. If he is taken out of the simple complaint arena, all of this authority that he's got to investigate, make reports, and recommend dismissal and all goes away. If it's the referral, he's basically nothing but a paper pusher, because the real party in interest is the complainant, and that's the person who has the role before the commission. So unless he's got some little edge in the back of this document, like recommending the hearing officer or something like that, he is essentially taken out of the equation. But you have to be very careful. I know it's not just about St. Croix, but I've dealt with this guy for years now, and I can tell you he is as intellectually dishonest as anybody, and it's on the record, and if he wants to sue me, he should, as any bureaucrat that I've ever dealt with.
All right, so do we leave it as is and make sure that we get rid of all his powers to deal with simple complaints, or do we change the wording to commission? Or both?
Well, my pugilistic reaction is to preempt them by putting the word commission in there and removing executive director from the definition. If they balk at that, then plan B would be to just make them a paper pusher.
Okay.
Yeah, but
But we want to do that anyway, don't
You're
we?
confronted with the fact that you don't want any part of 4 in this document at all, and that's where most of the damage will take place.
Right.
And so the other place that it comes up is who's going to send the notices out and so forth. The commission isn't going to do it. You know, that's his job. And that's the same as Chris's job. You know, he notifies the parties when there's a hearing. He keeps track of all the records and so forth. And that's what you want the staff to do. You don't want them engaged in the process of determining whether there's either a violation or enforcement is proper or whatever. And or in the case of selecting somebody who could be involved in that decision-making process.
Member Nee.
Yeah, I tend to agree with Bruce on this. I kind of disagree with Member Snyder that our doing this would be pugnacious or viewed as pugnation. We could even say, you know, we recognize that there are certain functions that the commission may want to delegate to the executive director or other members of staff. However, our purpose is to place full authority and responsibility in the commission's hands. We don't have to.
I think the best place to do that, Rick, is where the issue is who's going to hear these cases, these referral cases. And the way he's drafted it, it need not be the commission or as a whole or even a member of the commission. It can be a hearing officer that they designate. Well, this, from our point of view, it's too important to have a third party that they designate decide, you know, make the recommendations and hear the evidence or whatever. I think, and as I said in my memo, this shouldn't take long. And it's too important to the community and to the work of the task force to delegate the hearing responsibility to a third party that doesn't have the responsibility that the commission itself has. And that's the place where I would make the case that we understand they have staff, we understand that they do certain things in other cases, but this is different because what they're being presented with is a complete package from the task force. There's no need to do anything more than to have a hearing before In fact, that's what it says, that he will schedule a hearing before the commission at its next regularly scheduled meeting. So what's this business about a hearing officer?
Okay, Member Wolf.
I would just, I don't know if you went over this in number 1, but I would just, in the fourth sentence down, just strike out, these regulations shall apply only to, and then strike complaints alleging violations of the Sunshine Ordinance and.
Where are you? What section?
So preamble, section 1, fourth line down. It's in the preamble. So
Yeah.
because that's where it describes what this whole thing is. The whole thing is. So they're saying that this whole thing applies to complaints and referrals. I'm saying remove complaints out of it completely, and the whole thing just applies to referrals. Okay, so that way when it starts out that, because everything is et sequitur. So you start out with something, then everything that comes after it is based upon what it starts out with. So that's my suggestion, just to cut it off at the knees, right at the.
Okay, I want to point out one thing that,
Sorry,
that
ankles.
And I hate knee-jerk, I don't like knee-jerk reaction either.
I think one of the other things that we can't afford to miss is the provision in 6734, the first sentence, which says, I think it's the first, it may be the second. Yeah, the second sentence. Complaints involving allegations of willful violations of this ordinance by elected shall be handled by the Ethics Commission. So they have the right to take jurisdiction of complaints involving allegations of willful violations, okay? And that's why they've got a whole bunch of things in these draft regs dealing with what is willful and, and so forth, and how they go about finding willfulness. So you can't quite say they can't handle any complaints for violations. What they can't handle are complaints that don't allege or assert willful violations.
But I think the purpose, the point of that is that the task force first determines whether it's a violation that subsequently is deemed a willful violation, and then they're activated.
Yeah, it's my understanding sometimes when we refer matters to the Ethics Commission, we specify we're doing this because we found a willful violation.
I know you do, but you don't have to. But what you're doing is you're referring an order. And the failure to comply with the order, it makes it willful, in my view, automatically,
Yeah.
because willful means a conscious decision not to comply.
Right.
So that's where, that's the law in California, in the
But
government
we're not
code.
disputing that we're disputing whether they can receive a complaint directly for willful violation. I mean, a person can't say that this is willful
They
violation.
can allege it's willful.
They may not know what is or is not willful violation. It's defined in the Sunshine Ordinance, and that is something that the task force has the authority to make a order of determination on.
But look, the task force is going to operate the same whether the allegation is willful or not. Somebody says, I want a record, they've refused to give it to me, there's a hearing, the task force finds that the record is public, it orders the department head or official to disclose it, that person refuses, and then the order is referred to the Ethics Commission for enforcement.
Right.
And whether it's willful or not is not the issue. On the other hand, 6734D talks about official misconduct, and that's when you have a special finding that there's a willful failure on the part of this individual to,
I'm still not clear what you're.
But look, Bruce, we can make it more complicated for them, or we can simplify it for them. And I think we have to simplify it for
I
them.
understand, but I am not understanding the process by which they, see, your premise is that anybody can go to the Ethics Commission and claim that there was a willful violation and they automatically have to take it up. Okay, that sounds like your premise.
I think they think that too.
Well, but we're saying it's not.
No, we're not. I'm not saying that.
I am.
I'm willing to let them hear complaints for willful violations if they want to.
To adjudicate them? And then provide enforcement? My understanding.
They will enforce it themselves if they find willfulness. The only question is, are the standards that they use satisfactory to make that determination?
But the Sunshine Ordinance already lays it out.
No, it doesn't.
It does say if you do not do this particular thing, it's considered a willful violation.
No, it's
which
not.
is
It doesn't say that.
official misconduct.
Nope. It doesn't. It does not say that. What it says is,
I mean, it does say that willful
the
failure.
willful failure of an elected official, department head, or other managerial city employee to discharge any duties imposed by the ordinance, the Brown Act, or the CPRA shall be deemed official misconduct. It talks about willful failure of an elected official, department head, or other managerial to discharge any duties imposed on. So it's not just failure to disclose a public record. If they have a duty to appear, for
Right.
example, and they don't, that's official misconduct. It has
Not-
nothing to do with the process for getting a public record.
I don't think we're in dispute in that.
So
I'm talking-
that's not the same as complaints involving allegations of willful violations. Those are different. And that's why the task force never, it should actually not.
How is it different?
Pardon?
How is it different? Qualify that. How complaints of,
A complaint is definitely an allegation, but what Mr. Grossman just read is stating that it is willful, that it is official misconduct. And once we have an order of determination, if we find that it's willful.
I'm not disputing that. All I'm saying is, Mr. Grossman had said that anybody could bring that to the Ethics Commission, and then they can adjudicate it, because they have to, anything that's considered official misconduct, they must act upon.
No, well, we're not talking, there's nothing in these regulations about official misconduct. That's
It
not.
says that if willful violation is official misconduct.
I think, wait.
You
so-
just
But
read
that's
it.
not in these regulations.
No, I know that. I know it's
Okay,
not in these regulations.
So take it out of the equation.
So then
There is stuff here on willful violations. And that's, the issue whether they can handle those or not is much, I would say, much closer than the issue whether they can handle simple complaints that allege just a violation. I mean, if I allege that a particular individual in the planning department won't turn over a record to me, and he says, I can't find it, or something like that, it's lost and I don't have the time to get it, I'm not sure that's willful under the definitions of a willful failure, okay? But that's the whole point of it, that you can allege, nobody that I know of who does this often talks about willful. They just say, I'm entitled to it, and they won't give it to me.
But go ahead, David.
Yeah,
Sorry.
I may be missing something. I sort of missed the very beginning of this discussion between the two of you, but Mr. Gross, when you read section 6734, the willful failure, I don't think you got to the second half of it, which I think is the critical portion for what you guys are talking about. Maybe you did, and I missed it. But it says complaints involving allegations of willful violations, et cetera, shall be handled by the Ethics Commission. Did we already go through this?
Yeah, he read that.
You did read that section? Because that's what.
That's what we're talking
Yeah, I know, but I mean, that seems fairly clear to me that complaints for willful violations shall be handled.
Right, I understand that. My point I'm trying to make is that the member of the public may not know what that is. And so then the Ethics Commission wants to then open the door to accept all complaints so that it can determine
Whether it's a willful violation.
And
Okay,
if they
that's what I
also,
missed.
if the member of the
I
public
gotcha.
also comes to us and we find it to be willful violation, but then the Ethics Commission in their process says that it's not, then what you end up with is the Board of Supervisors saying, well, we have a duplicative process here. We don't need one or the other.
You know, there's a division of labor involved here. The work of the task force is not to find, to determine whether a violation is willful or not, because it doesn't change the calculus. What it has to determine is whether there's a violation, willful or not, and then try to remedy it. And if it isn't remedied as required, it goes to the Ethics Commission. On the other hand, the willful violation concept is the kind of thing that the Ethics Commission should deal with, because after all, there's a distinction between official misconduct, which is the first part of 6734, and the second part, because official misconduct cases are serious cases. Willful violations are just that. They're willful violations. If they're willful and the Ethics Commission finds that they're willful, then it can decide, in addition to requiring compliance, whether there should be some penalties associated with. There is, in the Government Code, Section 1222, a section that deals with this kind of issue. And it talks about what's willful, and the courts have construed it in a way that I think makes sense. Namely, if the person that's charged with the responsibility understands the responsibility and decides not to do it, it's willful.
Okay, so
What section of the regulations are we talking about? I mean, is there a section of the regulations that this is pegged to?
Well, the problem has to do with the fact that the preamble talks about complaints, only to complaints alleging violations of the ordinance and referrals from the task force. And Bruce suggested deleting the words
Okay, all right.
complaints alleging violations of the Sunshine Ordinance. And I'm saying
You can't
that they
do that.
could, I think they do apply to these willful violation cases.
So how about complaints alleging willful violations
Right,
of the
we add
Sunshine?
the
Just
word
edit it
willful.
to say, these regulations shall apply only to complaints alleging willful violations of the Sunshine Ordinance and referrals from the Sunshine Ordinance Task Force.
So,
A complaint where
So-
somebody says, this is a willful violation, I don't imagine there are a whole lot of those.
so does, no,
Are there?
how many determinations have we?
No, but the complaint has to allege that.
No.
Under the plain
no.
text of the ordinance, the complaint has to allege a willful violation, and I haven't seen one of those yet.
No, we have had plenty of them.
Have we?
I mean, Mr. Grossman and the rest of
Yes, people who
the
know what they're
posse
doing.
have brought, they have suggested, that's exactly what they've suggested the result to be. And,
right.
I mean,
They're-
it's,
They're willful, but it doesn't change the calculus before the task force. They're going to do the same thing whether it's willful or not, because they cannot take the step of doing something special unless it rises to the level of official misconduct, and that talks about a failure to discharge duties, and that could include a lot of things besides failure to deliver a public record in compliance with an order of determination, particularly when the guy says, oh, well, the city attorney told me I didn't have to do it, that kind of stuff. So it's a totally different set of rules. And if you look at page 7 of these regs, that's what they talk about,
I'm not,
C1-2.
I want to just render my uncomfortability with that explanation, because I don't believe that that's necessarily the case. My understanding is that they are to immediately deal with official misconduct cases, not willful violations. If the ordinance describes a willful violation and equates it with and says that it is a official misconduct,
It does.
then
But it doesn't.
It says.
It does.
The willful failure shall be deemed official misconduct.
that's how I've always read it.
Failure to discharge duties by an elected
That's a
official.
different section.
No, that's
No, but it says
6734.
the willful failure to discharge any duties imposed by the Sunshine Ordinance. How is that different from?
Here, yeah, the title, look, the title in the actual, of the actual section says it. It says willful failure shall be official misconduct. That's the title of the section of the ordinance.
Well,
I'm just trying to understand your
you know,
premise.
I don't want to make more of it than I should, so I just will let it drop.
I'm not, I don't know why you're doing that. I'm just trying to
Doing it
understand.
because what you're saying to me is that my education as a lawyer and all the experience I've had over the years has not given me any better way of interpreting this than somebody who's.
I understand
your
that,
job.
but at the
And
same
I-
time,
And that I have
Mr.
trouble accepting
Grossman,
that.
I respect you for all that. My grandfather was attorney, and a lot of my uncles were. Okay, I'm not an attorney,
Why don't
and
we move on?
wait a minute. I have an open mind, and I want to learn. So I'm trying to understand what you're saying so that I can learn it, and it's for the benefit of the rest of us, because I think some of the rest of us here have a different understanding of that.
Okay, well, I
So-
suggest then that you, if there is a next hearing before the commission, and I think even better, you should listen to the audio recordings of the commission hearings when Chemo and Chafee and Warfield and I were before them and this issue came up, and see if you get a different slant on it, that's all. I'm just telling you what I understand their view is.
But
And
can their
and I
view be
can't
wrong?
dispute it because I think it's fairly clear. Now, if somebody walked into the Sunshine Administrator's office and he says, pounds his hand on the table and says, this is a disgraceful violation, it's willful, it's mean, it's evil, Chris can say to him, if you really feel that strongly, you go over to the
Ethics
Ethics
Commission,
Commission,
right.
because they can really deal with a guy like that.
Mhm.
So to move this along, in the preamble, is it the consensus or near consensus of this group that we add willful violations? Add the term willful? Mr. Grossman, Member Nee, everybody else? Member Johnson?
I'm comfortable with adding willful.
I'm comfortable with that. So the sentence would read, these regulations shall apply only to willful violations of the Sunshine Ordinance and referrals from the Sunshine Ordinance Task Force? Is that what we're?
To complaints of willful violation.
Complaints
I
alleging
mean, of willful
willful.
failure.
We're just adding the adjective.
Just to point out, the ordinance only says that they should be handled by the Ethics Commission. They don't say it should be handled in the first instance by the Ethics Commission. Doesn't mean the Ethics Commission has to hear them first. It just says they're handled by the Ethics Commission.
I understand, and that point was made.
Already?
Yeah,
I'll
but
pay
I mean,
closer
there's
attention.
something to it. I mean, this is not a well-drafted law.
Yeah.
Everybody was complaining about it, handles.
Yeah.
What does that mean, handles? You know? But I think they, as a group, think that they have jurisdiction on willful violation.
In the first instance.
In the
They're-
first
As a group, they
instance.
think they should get them first before we, okay.
And that may be the way they think, group think. It may not be what's true and factual. It may not be the way it may be, they may be misinterpreting things. And I'm hoping this particular document helps to try and clarify some of their possible misconceptions.
We can hope.
Well, you know, it seems to me, for better or for worse, if we can get them to accept that, to limit their work to just so-called willful violations, then we're a lot better off than getting into a big argument about the simple complaints, to be honest with you.
Mhm.
Because we still have to get past that. So, you know.
Okay.
All right, moving to section 3C.
Madam Chair?
Yes, Member
Oh,
Neal.
In line 1, I would, or line 1 or 2, I would add the words Board of Supervisors. If the task force or a complainant notifies the Board of Supervisors, comma, District Attorney or California Attorney General of a violation, et cetera, et cetera, et cetera.
I think they took this right out of the statute, though.
yeah.
And the statute, I think, only talks about the AG and the district attorney.
I have it right here because I have a question about it for one of the attorneys. It's 13. It's C3.699-13, investigations and enforcement proceedings, and they are their definition in the legal memo. They kind of explain that they took it from that section. And one of the questions that I have about it, legal questions, is that the last part of it says that if it goes to the district attorney or the attorney general, that they'll wait 40 days. And Mr. Grossman addressed that delay of 40 days in his memo. But in that same section that they took it from, it says, within 10 working days after receipt of the complaint or information, the district attorney and city attorney shall inform the commission in writing regarding whether the district attorney or city attorney has initiated or intends to pursue an investigation of the matter. Since in that same legislation, in that same part of the charter, it discusses 10 days. Why do we have to accept their 40 days? If the district attorney and the city attorney can be required to respond to them within 10 days for something they refer to it, why can't we have that same consideration since it's from the same law?
6735D, any person may institute proceedings for enforcement and penalties under this act in any court of competent jurisdiction or before the Ethics Commission if enforcement is not taken by a city or state official 40 days after a
Right, but
complaint is filed.
this is saying that they won't do anything for 40 days. That's just giving a deadline. That's just giving an amount of time for the Ethics Commission. I mean, that's giving so that people don't go running off to a court or whatever immediately. That's giving the different departments time to respond. In the regulations, it's allowing the Ethics Commission to delay for 40 days, even though their own investigation. It's also a way of keeping people from notifying the Attorney General, which is, and the District Attorney, which is another way of not having the Ethics Commission monitored. It's sort of trying to keep them from, because it'll increase their time, they'll increase their wait. It'll delay their due process for 40 days, even though in their own charter regulations, it's only delayed for 10 days. The 40-day rule is to give the departments ample time, the Ethics Commission or whoever has the complaint ample time to respond. Say it's a huge investigation. They don't want to let the complainant just run off in 2 days and say they're not responding.
Mhm.
But in the regulations, it's actually delaying due process for 40 days, sort of curtailing or trying to keep people from thinking that going to the district attorney or the attorney general is a good idea.
Well, wait a minute. Let me ask something. Reading this, I'm going to break it down into parts. Any person may institute proceedings for enforcement and penalties.
But
under
that's
this.
not what that section is coming from. It's coming from this. It's not coming, you're reading that 40-day rule. They're incorporating that 40-day rule into their 3699.
Talking about
Except
paragraph C of the.
Except 6736 says, titled, Sunshine Ordinance supersedes other local laws. The provisions of the Sunshine Ordinance supersede other local laws whenever a conflict of a local law is identified, the requirement which would result in a greater or more expedited public access to public information shall apply. Well, that doesn't apply to necessarily enforcement.
But if you look at their explanation of that particular paragraph in their memo,
But give me a
There-
page.
it's on page 4 of their memo. It's 21 of our original packet. I don't know what. So, section toward the bottom underneath that block that says decision point 3B, it says section 3C clarifies the administrative exhaustion requirement. So it does refer to 67.35. But the last sentence of that, it says the ordinance does not define what it means to file a complaint before going to court, and it does not define enforcement action. So Prop G didn't define those. I looked it up, and it definitely does not define those, which was kind of a mistake on the people of Prop G.
I don't understand. File a complaint. File complaint is all through the Sunshine Ordinance, just coming to the task
It's not,
force.
it's never defined. It's never legally defined. Look it up. It's not file and complaint is not defined in the Sunshine Ordinance nor in Prop G. It's not defined.
Does it need to be defined?
Yes,
Why?
because people like the Ethics Commission use those words against you. That's why the definitions are so important.
Does the rules of court procedure define file a
Yes.
complaint?
Yes, the Civil Code of Procedure defines everything.
Then if it were to be challenged in court, the court would probably say it means the same thing.
No, Prop G does not define it. You can't make that assumption. It's a mistake. And
That would be an opinion of the court. And the court can make that ruling if somebody wants to appeal it and take it all the way up to the Supreme Court.
that's a foolhardy risk when you could just define it and have it be done with and take no risk. You're taking a risk that the court will side with you for no reason. It's a risk for no reason. If people in Prop G had actually defined those things, they wouldn't. I think this is retaliatory for Prop G. But beyond that particular argument, it says the ordinance also does not indicate which city or state official has the power to consider complaints under the Sunshine Ordinance.
Of course it does.
This is from their. This is
Oh.
their legal analysis, not
I
mine.
see what you're
I don't. I'm just trying to point out that they're saying that
That's
by
actually true.
regulation they can adopt a reasonable interpretation that clarifies the 40-day requirement. So they're kind of putting that 40-day requirement with the city attorney and the district attorney requirement, even though the thing that they're taking that from makes the district attorney and the city attorney respond to them within 10 days. So the 40-day rule here is to give ample time for people to respond, for the appropriate departments to respond before a complainant who may be a lay person who may not know. But their provision in there provides the Ethics Commission with a way to delay due process for 40 days just by picking that particular ordinance, when we could go back to the other one and say, but they can respond to your complaints. If the Ethics Commission sends a complaint or an investigation to the city attorney or the district attorney, they have to respond to them within 10 days. Why shouldn't they have to respond to one of our complaints within 10 days or to a layperson's complaint within 10 days? Why does the Ethics Commission get to wait 40 days?
How
I see
how
what
would
you're
you fix it?
I would say 10 days
Right.
instead of 40 days.
Well, how do you then explain the 40 days in the 6735D?
Because it's allowing, it's not in the hand, that's when it's in the hands of, the difference to me is that this provision in the Sunshine Ordinance is allowing ample time for an action to be taken by an enforcement, whoever is the enforcing agent, so that a complainant doesn't press something that they're not sure of. But in the regulations, they're saying that if the complainant should dare to send this to the district attorney, it's going to force them to wait that 40 days, as opposed to giving the department 40 days.
Well,
Because
you
they
know,
have to respond.
It's kind of a chicken and the egg, because 6735D is the section that they're relying on to take jurisdiction of simple violation complaints, right? We're not
Right.
talking about referrals,
Right.
and we're
but-
not, and I'm not sure we're even talking about willful violation. Okay, we're talking about complaints, which may include both simple or whatever.
But you're
Let
preventing.
me finish. So if that person had filed before the task force, there's a 45-day rule, which means that they have to have their hearing within 45 days, right? Before the task force. That's,
Okay,
I
but
think,
let's
in
say
the-
that something
let me-
happened.
I'm just trying to give you some parity between a complaint filed before the task force and a complaint filed before the Ethics Commission. So if the complaint is filed before the task force,
That
It
doesn't,
does-
so this
it-
isn't
it's-
about the Ethics Commission having it filed before the Ethics Commission. Like, let's say that that woman that came in who said that she was, I think it was the Adult Protection Services, she said she had an altercation with the person. Let's say she filed a complaint because she couldn't get her records, but she
Right.
also filed a complaint with the district attorney because she felt she'd been assaulted. This automatically makes her wait 40 days.
to do what? To
For the Ethics
enforce an
Commission,
order.
yeah. Well, if
To
we came
enforce an order, which means that the complaint could be filed on January 1st, and the order could be issued on the January 31st, and then she's got 10 days to wait, because the time runs from the complaint being filed, not when the order is issued.
well, it says they won't take an action on the referral or the complaint. They won't take any action for 40 days, which delays it even more
Well,
than
then,
if they
but-
didn't
but-
refer it to the district
But
attorney.
that 40 days in 6735D means something. It's there, it can't be ignored. So what they're saying is, we have the right to try to figure out what the meaning of that is and to apply it in practice. What you're saying is, you don't agree with them. You think the 40 days should start at some other point.
No, I don't
Or
think
you
the
don't
40
think it should apply at all.
Member Wolf.
I think you have to read section 6735D very carefully, okay? Because the if part is important. If enforcement action is not taken by a city or state official, enforcement action not taken by a city or state official. The city official is the district attorney. The state official is the attorney general. That is the two city and state officials that are named in the ordinance. And because they're already named in the ordinance as such, that would flow all the way through the end. That makes it et sequitur.
I'm right there, though, but that doesn't prevent the Ethics Commission from taking an action before that 40 days.
I understand. Well, I understand that. This is, Section D is only if the enforcement is not taken by a city or state official, okay?
And in the regulations, just referring it to the district attorney, just referring it before you even know that there's an enforcement action needed is going to trigger 40 days.
Well, if I guess I'm not making myself clear. If 6735D relates only to enforcement and not to the original complaint, then when the complaint is filed, if there's a notification given to those two officials, by the time the order issues out, the 40 days has probably come and gone. so
Right.
it becomes irrelevant.
Well, why are you allowing them to have it?
I'm not
You're-
allowing them, I'm just telling you, we haven't gotten to that yet.
My
But-
only point
but-
is
but
that they're,
the simplest way for the task force to deal with it would be to notify those two bodies when a complaint is filed. Just send them a letter. And in fact, what St. Croix used to do, when he treated the referrals as complaints, he used to actually write a letter to the city attorney and to, I think, the district attorney, asking them if they want to take any action on it.
they don't do that.
And
anymore.
they always replied, no, we're not interested. So.
Well, why should it be different for
What I'm
the-
trying to say is that in the natural course of time, that 40 days will run from the time the complaint is filed by the time there's an order entered and there's
Okay,
non-compliance.
But why should it be different for the if the Ethics Commission refers it to them, if the Ethics Commission refers it to the district attorney or the attorney general, they must respond to the Ethics Commission within 10 days. But if we refer it, but if we refer it or the person refers it, they don't have to do anything for 40 days.
Where's the 10-day rule? I'm sorry.
That's in
It's
the
in-
Ethics Commission's, in
In-
their part of the charter.
It's C3.69913
Yeah,
investigations
but
and enforcement.
that doesn't apply to open government cases.
Yeah, the rules of open government, I know what you're saying.
I'm just
I
saying
know
that
exactly what
they're
you're saying.
putting a provision in here that's purposefully delaying due process, but only if the complainant should do it to it. The district attorney's office and the AG are two of the only departments that can actually monitor the ethics commission. We can't really do anything about it. But if the district attorney and the attorney general sees them not doing something about it, they can. And so if the complainant refers it to them, it triggers a 40-day rule. But if the Ethics Commission refers it, they only have to wait 10 days. And I understand what you're saying about the time and that it doesn't matter, but I don't understand why you would just give them that. It's another
Well,
tool.
I'm trying to make sense out of it and deal with it in a way that's as practical as we can make it, because I'd rather fight with them over stuff that's really important than something that I think is going to kind of cure itself, you know?
But that's it's true that it's maybe not as relevant as the hearing things, but the district attorney and the attorney general are two entities that can oversee the ethics commission.
Yeah, but they don't. And this practice of notifying them that a complaint has been filed is not part of their oversight function. It's part of their basic enforcement function. That's different.
But it's not there. It's the notification by someone that's been injured that triggers a longer delay than the Ethics Commission's own notification.
Except that under the rules of the Sunshine Ordinance, it specifies 40 days. So that's the rule of law. It's the bar. Now, if you're
That's
talking
only
about
40 days after an enforcement action has been deemed to be.
No, complaint. It says complaint. Read section 37D again, 35D again.
No, it doesn't. It says if enforcement action is not taken.
After a complaint is filed, 40 days after a complaint has been filed. If enforcement hasn't been taken 40 days after a complaint has been filed. So if you come here, you have to wait. You got to go through the complaint committee, so that's 2 weeks. And then after that, it's got to go to the task force, that's another 2 weeks. Okay, it's already 30 days. By the time it gets written up and the order of determination gets sent to the commission and they process it through them, it's already been 40 days. It's a matter of just process time that I think because then what it would force the task, it would then force the task force to have meetings almost every day of the week.
Member Nee.
We could change the language, or recommend a change in the language. The executive director shall take action on the referral or complaint regarding that violation or alleged violation no fewer than 40 calendar days and no more than 47 calendar days after the notification date. That knocks out any,
if
means
you-
that's giving them, that's giving them the 40 days.
Because it
And-
says if the task force notifies the district attorney, they've already waited the amount of time that you guys are talking about. So if somebody files a complaint, it takes 30 days to get through the process, and once they come before us, we decide we're going to notify the attorney general, that's another 40 days, automatically.
No,
It says
it's-
if the task force notifies the district attorney or Kelvin of a violation, the executive director shall not take action on the referral or complaint for at least 40 days. So you're delaying the due process by an additional 40 days, potentially. And I understand that it's not that big of a deal, so I'll be quiet now, but I don't understand why you would automatically give them that provision. If we refer or a complainant notifies the district attorney, it doesn't say after a complaint, it doesn't say at what process. So the person could come all the way through here, and we once, and that protective agency, it's a deterrent to notifying two of the only agencies that could have punches at the ethics commission. So somebody could file the complaint, and it could take 30 days to go through, and it says if we had referred that woman at the Adult Protective Services, she'd already waited a significant amount of time for it to come before the task force. And if we had referred it to the Attorney General, which was a motion that was made, that would have automatically triggered another 40 days. But if the Ethics
No.
Commission just, yes, that's what this
No,
says.
it doesn't, but 35D specifically says 40 days after a complaint
But
is filed.
that's not what C says. C says
no,
if
C-
the task force notifies them, it triggers 40 days, no matter at what point, no matter how long it's already been.
But they are using in their summary, as you pointed out, it says that section permits any person to institute proceedings in court or before the commission if the enforcement action is not taken by a city, state official 40 days after a complaint is filed. They then try to muddy the waters by saying the ordinance does not define what it means to file a complaint.
But
Well,
you
that's an
file it and
opinion.
then-
That's their opinion. Who
Why,
cares?
why can't
Who
we
cares?
head this off at the pass by requiring the Ethics Commission to notify these two officials when a complaint is filed? Just require that as part of the regulations. And obviously, when a referral is involved, if the task force has done the same thing when the complaint was filed, then by the time the process cycles through, the 40 days will come and go. That way, there's no issue about who has the responsibility of sending the notice and when does it have to be sent. If it requires the Ethics Commission under its own regulations to immediately notify these two officials that a complaint has been filed, that'll cure the problem. The 40 days will run, believe me. And if the task force own rules require the same thing, it'll cure the problem from this end. So that's what our suggestion could be. And that's one that I think would make sense because it talks about a complaint filed.
But their regulations does not talk about a complaint filed. So I
Well, it
just want to
doesn't?
keep that.
I want to make a suggestion for some language change here in C. Okay, the second to last word, the sentence ends until at least 40 days after the notification date. Strike notification and put of complaint date. And then that puts it smack in compliance with 35D. Just remove the word notification date. They invented that. They invented the word notification. The existing law is complaint, the date of the complaint. And if they're going to refer to the date, if they're going to refer to that in their summary and then make an opinion that there's no definition of what filing a complaint is, come on, that's frivolous to me.
I like that.
Yeah, me too.
They are, if there isn't, then they must act upon it immediately.
They're still bound by the ordinance, aren't they?
Because not everything gets referred.
Do you expect any city or state official to act on a complaint within 40
Microphone.
days after the filing They never hear about it. They have to read about it in the Chronicle. They have to get notice, that we know. Otherwise, it doesn't make any sense at all.
No, all this
So my
is-
suggestion is give them the immediate notice, it'll cycle through, and that'll be the end of the story. Otherwise, their interpretation is, well, when you guys get around to giving the notice, and when we get around to giving the notice, or when the complainant gets around to giving the notice,
But there's no
that's when the 40 days starts to run.
But there's no dispute when the complaint date is. The complaint starts at a certain time. That's when the clock starts ticking. When the complaint is filed. If it's filed with Chris, then that's when it starts ticking.
He notifies them immediately. That takes care of it.
Right. And so if the as 35D states, if enforcement action is not taken by a city or state official 40 days after the complaint is filed. So from day one that it gets filed by Chris, if no enforcement action's been taken for 40 days from the day it hits his office and he submits it for the complaint committee.
Sends an email right then and there. They get it the same day.
Oh, you're saying just so that the Ethics Commission has notice of when the complaint date starts?
No, when the complaint is filed, it doesn't say with whom. It just said when the complaint is filed. If you take their interpretation that this gives them jurisdiction over plain vanilla complaints, then they have to have the same procedure that the task force does, which is to immediately notify the city or state official. And that's what starts the 40-day clock running.
Member Nee.
Let me just suggest some alternative language here at the end. Until at least 40 days after the complaint is filed with the task force. Or within 40 days after the date of the filing of the complaint with the task force, something like that. I would say 40 days after the complaint is filed with the task force.
I mean, the problem with that,
What's that?
the only problem with that is then that gets into their little silly dance about whether file or complaint is defined.
And also
That
this-
exposes it to that kind of
Well,
ambiguity.
after the date the complaint is filed with the task force.
I'm a little confused. Task Force has been in existence for how many years? And we've been, have a
16.
process for accepting complaints and filing complaints. There is such a thing as a regular rule of practice that a court would consider to be regular. If it's been instituted and not disputed or anything, Ethics Commission has never disputed the way we processed our complaints, ever.
It's because they dismiss them.
It is no. They don't dismiss the complaint. They dismiss the enforcement. That's different.
They treated it as a complaint.
It's not though. That's not the way it's going. They can do whatever they want. The question is the way the law and the powers that be that make the opinions about the law are going to determine what that is. And that I defer to you as to whether how that might be.
I think Mr. Grossman's idea of notifying them covers whether a city or state official has been notified, because what he's saying is, how would they know to take any action? Although that, to me, that's more of a, if an action is needed, because not an action isn't needed in every single
But
instance.
if they receive it after 40 days, if they receive it in 30 days, okay, and there's no contact with the city or state official, okay, or if they receive it in 47 days and there's no contact, it's gonna be part of that record anyway. If they receive it in 30 days, it's gonna be part of that record too. Now they may just say, well, we'll just wait out the 40 days. I agree with you. Then that doesn't provide due process, when in all other cases before the Ethics Commission, they must make notification in 10 days. I hear you. But we're talking specifically about sunshine cases. We're not talking about other cases. So the rules for, sorry?
the Ethics Commission refers a sunshine case, they would have to respond in 10 days. The district attorney and the city attorney have to respond
It
to investigation.
refers to who?
It says, this is about investigations of campaign finance, lobbying, conflicts of interest, or governmental ethics.
Yeah, but
That's
I
different.
explained, those are not.
Open
they don't-
government.
Open government rules. They only apply to those 5 instances where the statute or the appendix is very specific on the whole process.
Well, willful
The
violation
open
is
government rules are based upon a single sentence in the charter, and they have a clean slate to write those rules. This provision is one that they're trying to include to deal with 6735D and the 40-day requirement. And the fact is that if it's an enforcement action only, then by definition, if they had notified the city or state official and the complaint was filed, the enforcement action will take at, I would say, minimum 60 days after the complaint is filed. So the 40-day rule is not a real obstacle unless it's done the way they want it done, which is to notify when the referral is made. You know, that slows it down by 40 days. But if the task force had, because 6735D doesn't talk about the date of a referral, it talks about the complaint, filing of the complaint. So I would just fix it by saying, 30 days from the filing of the complaint. Period.
I just want, go ahead.
It's just that the
40 days.
just notifying them, it's not a necessarily, when you're talking about notifying the district attorney or a city or a state official, like it says in here, there's a difference between just a general broad notification that something's been filed and something they need to take action on. So I just wanted to point out that we're giving them another way of delaying the process for 40 days because it's not necessarily.
But not if the task force does its job and if they're required to do the same thing.
So if we were
They
if
would
we make a referral,
They would
then
send a
send it
copy
to
of the
them.
complaint to the 2 officials the same day it's filed or the next day, and that would start the clock. 40 days starts running. And then
Yeah.
who's going to complain?
whatever you think would work
Who's
is.
going to complain? Is Mr. St. Croix going to say, well, it's true, it's more than 40 days from the date the complaint was filed, and yes, they did get notice, but it wasn't really notice? I mean, what is he going to say?
Okay.
One of the other points I just want to make is their responsibilities under Sunshine versus their responsibilities under, let's say, the Political Practices Commission. The Fair Political Practices Commission gives them specific authority to dole out penalties and fines for campaign and any other kind of finance reporting. Nothing to do with Sunshine.
What about official misconduct? That's government
Only
ethics.
only within regards to the duties, Sunshine aside, all other duties. Sunshine has its own set of rules with regards to willful failure. It's not the same set of rules as all those other.
These are rules that govern the Ethics Commission.
I know, but
You don't get to pick and choose how this is how their investigations and enforcement proceedings are governed. And you can't automatically.
But are those,
Not
doesn't
in open government cases.
Yeah, not in open government cases. It's only in regards to items that are regarding fair political practices.
No, and government ethics, which is official misconduct.
It's
No,
But I understand what
official
you're saying.
misconduct is dealt with specifically in the charter sections creating the Ethics Commission. And they'd have to deal with those separately because they involve very serious penalties, removal from office, so they need due process and everything else. That is why these regulations do not cover references for official misconduct.
Okay, with regard to 3C, is there consensus or near consensus to add the language at the very end? Alleged violation until at least 40 days after the complaint is filed with the task force. Can we live with that for now? It's not in concrete
I
yet.
thought we were just going to refer it automatically.
Refer it to who automatically? To the AG and the DA?
Give notice, I guess. That's what Mr. Grossman was saying. We can
Oh,
go on
I
to
mean,
the
at
next
at the
subject.
time of a complaint being filed, that notice would be given to the AG and the DA that a complaint has been filed. In the microphone, please, so we can get on the
That would
record.
be our explanation to them, that it would, otherwise it delays what is already a prolonged process if they wait until some time after the process is either started or finished. So they should make those notifications immediately, and so will the task force.
So should we capture that in 3C?
I mean, I think it's, it's an added protection. I think I mean, that's what it does. I think that we're covered just by adding the filing of the complaint, because that starts the clock ticking no matter what. And our own process takes at minimum 30 days.
Right.
So, and most orders come through this committee anyway, which is 2 weeks after
Right.
the order's been made. So
Member Nee?
I don't know.
Yeah, I would specify, though, after the complaint is filed with the task force.
Yeah.
It-
Right.
It
Yeah, I agree.
gives them much less wiggle room.
Right. All right,
Now,
it's,
I have one other question, and I believe that Hope had brought this up before, and with Mr. Grossman's suggestion that the Ethics Commission can take complaints of willful violation directly and circumvent the task force. And if that's the case, and then they want to follow the same rules of 40 days, the question, then the question is it the same question? Are they still following the Sunshine Ordinance, or they now have entered a different venue? So you have the
Right.
Ethics Commission, and then you have the Sunshine Enforcement Commission. Let's separate them like that. Okay? So does them taking on a willful violation directly as being a violation of the Sunshine Ordinance, are they still the Sunshine Enforcement Commission, or are they now the Ethics Commission taking on an ethics issue?
That's not clear, because their view, I think, is that a section of 6734,
6734 is,
they handle complaints of willful violations. Isn't it?
complaints involving allegations of willful violation of this
So
ordinance.
Their view is that that's an original jurisdiction, confers original jurisdiction on them to handle those complaints.
So then
They
it would
want
be
'em.
the Ethics Commission, not the enforcement of the Sunshine Ordinance Commission.
That's a different hat.
That's a different hat.
Right.
So your 40 days at that point makes sense, because under the Ethics Commission's rules, it's 10 days. Because it's not Sunshine Ordinance rules at that point. Did I get that right, Mr. Grossman?
Yep.
but 3C just is regarding simple complaints filed with us. Okay.
Okay.
I'm looking at the clock, wondering, do we press ahead for a while longer, or we have a long ways to go, everybody?
It's up to you.
We could,
I'd like to hear what the members have to say about
I mean,
it.
I'm okay for pressing on, I'd like to get through it. We've been, through what, 3 meetings and not
Well,
being
you
able
know,
to.
The thing is, Bruce, that we've spent 40 minutes or so talking about a 40-day rule, when we've got some really important stuff that is going to impact every referral. And we may as well deal with that, because if we don't, then it's going to come out the way that we don't want it.
I'm saying, I'm all for pressing forward. That's what I'm
Well,
saying.
Dave is a litigator, and I'm not, so part of it had to do with the nature of the hearing on a referral. We can talk about it, I'll hear for a while.
I'd like it to at least request a 5-minute recess if we're going to press on.
Okay, I have, yeah, that's fine, but I have some constraints too. I can't stay much longer than 8 o'clock
What I would,
myself.
what I would
Fine.
suggest is, if we can either press on now or call a special meeting of the committee, perhaps the first week in November.
Why can't we meet in a week?
Well, we could do that too.
I can't do it. I won't be able to make it. It's too difficult on my workplace.
Or we could do it.
Unless you want to change the day to a Thursday, which is my work from home day.
Or we could do it.
I can't do Thursdays at all. I teach in Santa Rosa.
We could do it Wednesday, the day after the task force meets. That would be the 27th, October 27th.
That's possible. Would that help?
I could do that. It's plenty of time for
Yeah,
me
I can do
to
that, too.
prepare.
Do we want to take a recess and stay for just a short time while we have Mr. Grossman here about the investigation?
I'd like to do
Yeah.
that.
Is that,
Yeah, let's go for another hour till 8 o'clock. Take a brief recess. I'm so glad you have all of this experience with. Huh?
Hope you had dinner. Well, we're going to go till 8, and then I'll head. Yeah, I'm not sure. I might stop and pick up something if I can think of a place that's open. Why don't you do that? Sure. Parked in the city lot next to,
University for having Sarah Palin. How much did they pay her? But the reality is, if Leland Ray was very effective, he would figure out a way, he can't. Sarah Palin comes in, and the city and the university can make all this money.
right next to, I want to say,
They can't even get a 20th of that money. See what I'm saying?
of course it's safe.
What difference does it make how much they paid Sarah Palin?
So I parked
He
it.
harasses them enough. Sarah Palin won't come. And now, so
Okay.
what? You know how much money she made? Big what? Now they get none of the money. Now there's zero. We don't have to look at anything. I'm not saying that.
Yeah, you
they
could do
shouldn't
that.
push for that, but when
You could-
everybody looks
back your car up.
Wow, I look at him and say, you've been there forever. Why is the university losing money? Why are you?
Okay, I'll see you later.
To the people who hate Sarah Palin, I want you to figure out a way to get money for the university. Get as much money as she did. That's your job, not, he can't bring in that money. They use it for politics, but when it comes to their politics, they are on it. So,
Yeah, this matter with Kamala Harris, trying to get information about her.
well, they'll push it back until
Oh, they have.
after the election.
Oh, they have, yeah, they wanted to continuance to the end of November. Well, that's way too late.
I'm dying to call that woman and ask her, who do they represent? Why does she want that? I mean, I can't, I won't, but someone else could. They could call and ask why they want that information. But I found the only way to circumvent them is to stop.
We should have written the regulations and sent them over to them.
Are
Yeah,
they,
preempted them.
they don't operate, what do they operate off of now?
Pardon?
Since these are new, the sunshine part of the regulations, all new, what standards or procedures do they use to,
They use the same ones that they use for campaign finance and breach of ethics laws and conflict of interest and all. But this is an open government process. So, and the executive director should have no role, because the real party in interest is the complainant, and the executive director is not the prosecutor, or the DA or anything like that. It's a fight between a complainant and somebody in the city, and they're supposed to be the arbiter. That's what they should, but that is what they have. All they did was take that awful set of very complicated rules that, as Rick probably knows, if you have to have a hearing before the Ethics Commission, it's not a simple, thing. It's very,
I sat through Tony Hall's.
pardon?
I sat through Tony Hall's Ethics Commission. It was like a court.
Yeah, well, that's what they want to do with these cases, but they can't. They want to make them into something they shouldn't be. Besides which, they want to keep a lot of the stuff secret. The staff's internal notes are secret and stuff like that. None of that applies. They can't do that.
That's the notes, that's the notes they manage not to lose.
Pardon?
I said, that's the notes they manage not to lose.
Can
Yeah.
they keep some of it as privilege, like if you're investigating? I mean, I don't know, but, like if, I used to work on sexual harassment cases, so if it's a claim of official misconduct, which you said was really serious, some of the things that they're asking would be privileged if it was asked by an attorney.
There's no privilege in open government cases.
But if it's official misconduct, it's an allegation, right?
Official misconduct is not part of what we're doing here. That's a totally separate proceeding where the city official is entitled to full due process protection. And
What if we
it means it's
refer
like-
that one to them, though?
Pardon?
What if they get a referral from us that's alleging violation of,
That there's official misconduct? It's in
And
the
it-
charter. It's treated as official misconduct under the charter, and it's handled under the charter, which is a separate set of
From-
rules.
from
Has
the-
nothing to do with open government anymore.
so those notes, that part about the notes would only cover the non-official misconduct?
Well, then they have a regular head Jew hearing that they never had.
Bruce is laden
Well,
with
it took-
snacks.
Well, originally, see, the 14 cases that St. Croix dismissed, 10 of them had official misconduct findings. And they treated them just like any other finding. You know, we'll reinvestigate, and if we decide there's no official misconduct, then there isn't any. But in point of fact, the charter doesn't say that. The charter says where official misconduct is found anywhere else by any other body, it is official misconduct under Article 15 of the charter and has to be dealt with as any other official misconduct, whether it's
Rather than
a
re-adjudicating.
Jew
them.
case, a Tony Hall case, you name it. And they finally figured that out, but of course, those 10 cases are now gone, unless we can get them reinstated.
Bring them to the Compliance and Amendments Committee.
Well, if I can find somebody to handle it, that's the next phase.
So under
'Cause that's
these
what they
new
should do,
regulations,
because they were
would-
all decided under rules that didn't apply.
Yeah.
Yeah.
That's why we have these rules.
So under these new regulations, they're self-imposing a new,
If they're gonna hear open government cases, they gotta have regulations, that's what it
Special meeting of the Compliance and Amendments Committee is reopened, is reconvened. Member Nee.
Yeah, I just think it's important to note that there is still nobody in the audience section,
Okay.
for the record.
The next section, Section 4.
Okay, Section 4, I think a good part of it is gone because it applies to simple complaints. Because if there's a referral, according to Section 3B on page 2, when he receives a referral, he schedules a hearing, the executive, at the next regular meeting, and such hearing shall otherwise be governed by the provisions of Section 5. So referrals are not governed by 4 at all. But 4 has a good deal of problems for the garden variety complaints. So my original thought was to deal with the referral parts first, because the chances of somebody, to anybody's knowledge, there's only been one case where somebody filed a complaint directly with ethics, but they also filed a similar complaint with the task force. So we never heard what happened with the ethics complaint, but nobody who has any, understanding of the differences would file before ethics. So, but it would be wrong to leave it stand because there's so much wrong with it.
So do we want to just strike 4 altogether?
Well, there are aspects of it, let me see.
maybe we could skip it now and do 5 while.
I think that you could, except that if you concede they can hear these willful violation cases, then you may need to keep it for willful violation cases. So I
Okay,
think
so
that's.
investigations would apply in that case.
Yeah.
I
but
think
e- But again, the balance is, should we let the fight be between the Ethics Commission and the city official or department head, or should the fight be between the complainant and the city official or department head, as it would be if that complaint had been filed with the task force? I'm a little less, I haven't developed a complete view on that. The problem is that since I don't trust St. Croix as far as I can throw him, and if you've ever seen him, that would be an impossibility.
Right,
I'd just soon get him out of there and just leave the real party in interest and handle it like you would a complaint before the task force.
Should we include that in our recommendations?
It's also, if he listens to this recording, he's going to hear that, which is okay.
So, all right, with regard to section 4, we've conceded, at least for now in the preamble, that complaints alleging willful violations can be filed with the Ethics Commission. So if that's the case, then we would have to let 4 stand because they would be able to do investigations. But what you're saying is, if we do let 4 stand, what we want to do is to tailor it so it looks more like how we handle things, with the complainant having an equal voice at
Yeah.
least.
Well, I would have it parallel what would happen if the complaint was filed with the task force. I would keep, in other words, I would keep the executive director and his investigation and report out of it.
So,
But it's tough because the willful aspect of it is buttressed in the hearing section, and I'm not sure how far you can go with that, to be honest.
all right, so do you have some language for us for section 4 that will, no.
I can work on it.
If you would, for our next meeting, that would be helpful. Do any of the other members have any suggestions that you want to share at this point? Member Nee?
Yeah, in 4B2C, I kind of think the language should be replaced. The entire paragraph, at least the first paragraph. And then that it would say, all staff recommendations should automatically go to the full commission for a public hearing. The reason I believe that is otherwise the rubber stamping that we find so objectionable can and probably will continue. That's my recommendation. We don't have to toss it back and forth right now, but I think it's, I'd like it to be at least considered.
Could I have that again, just?
Yes. In section 4B2C, where it says finding of no violation of sunshine ordinance and dismissal, I would certainly cross that out. I would just say all staff recommendations should automatically go to the full commission for a public hearing.
And then the rest of it remains the same? Oh, wait, a lot of that's going to go away.
Yeah. I think that should be the premise. I think that should be our starting premise rather than finding of no violation. The executive director shall so inform the commission, et cetera.
Do you see any reason why he even has to make a recommendation?
I'm sorry?
If he's going to be the one to do the investigating and everything, why does he have to make a recommendation? He can just provide a summary of the facts with supporting paperwork and make a declaration out of it and put him under oath, and this is what he's found and so forth.
Sounds good.
And if, and let the commission decide on a full hearing after it's heard the arguments about the facts alleged in that particular report, whether it amounts to a willful violation or not, and go from there. I mean, it would be tough for an individual complainant to do all the work that an executive director with a full staff can do. He can, the complainant at least will have the opportunity of adding to the report or filing his own report or his own statement with maybe under oath also, because, they're talking about penalties if there's a finding of a willful violation, so I think that they have to raise the stakes for everybody.
Well, in that case, couldn't we just have the one paragraph right after report of investigation, 4B, and then knock out the number 1, just have that one paragraph? We don't need 2, A, B, or C. We could make that our...
The best way to handle it is to reduce the role of the executive director and allow the complainant to get his licks in, and then have the hearing. But I do think it has to be before the commission and not a hearing officer.
Right.
Would that also, what you just suggested about letting the complainant have more input? Because in 2B, if the executive director recommends a finding of violation and settlement, what if the complainant how would they appeal a stipulation or a settlement that they didn't agree with if they had no say? So that would sort of remedy that too.
If they want to resolve it with the city official, I mean, I went through this myself when I wanted records on tree removals, and we met with the supervisor of records, and the city said, well, we'll give you this information, but we still want to keep this out. And I said, that's okay. And that's how we resolved it. So it's possible to do. It's done all the time.
But this is a stipulation between the person accused
It
and
would
the
be the
commission.
real party in interest would be the complainant.
How do they get that power, though? It's not in here. Is it something we could write in here?
I'm having trouble hearing you.
Yeah, well, because
what power?
in 2B, it allows the commission to enter into a settlement agreement with the person who's accused.
This
And there's no way for the complainant to appeal
Well,
it. or
there
anything.
won't be a recommendation in the report the way we've just talked about it.
So that would remedy all
So
of that.
it's the issue is still totally open. Nobody is taking a position on it other than the complainant
Okay.
in the city. So they can resolve it if they want to. It's just stipulate and it'll go away.
They're trying to apply their current enforcement process to this. And that may not work for this kind of thing. It works for the general, everyday Joe and Jane that are running for office, that have no clue about how any of this works. They're just a general citizen that tried to enter into an election or something like that. And they're trying to help them out. So they're 10 days late with a filing. So instead of charging them $100, they can, kind of petition with them and say, I only got $50 in the bank. Will you take that? That's the way they're trying to work with it. We're dealing with city employees, city officials, part of their job description, sunshine ordinance. This is like a really big deal. This is like the mayor not doing his job kind of thing. So, I think their process, the way they're thinking about their process, is they're trying not to make it too complicated for the commissioners. The commissioners aren't even involved at all. The only thing that they get to hear is this case was settled for $50. We just need your rubber stamp for that it's done. That's it. That's all they get to hear when that stuff comes. So I think that's kind of what they're trying to do here, but it makes the cases seem frivolous then, right? So so then maybe we should help them by providing some guidance as to what we think how penalties should be dealt with, and whether they can be stipulated or not, or whether it's like, well, you get busted for, well, soon probably not pot, but you get busted for pot, it's a certain amount of time. You get busted for cocaine, it's a different amount of time. Get busted for heroin, it's a different amount of time. Do you have a schedule of how that works, or is there something existing that can be used? I don't know. Has Mr. Grossman or does anybody know? Have they ever adjudicated or did enforcement on any official misconduct? Well, they did with Ed Jew.
Well, they never actually went all the way. He resigned.
That's right. He resigned. So
They don't have a set of rules.
So they really don't have an experience of having to do real general ethics enforcement. It's all been about filings for, for elections and stuff like that. Lobbyists and things like that.
All right, getting back to section 4. So it was suggested that we strike everything after B1. So we're left with an A and a B. With the
There would not be a 1 and a 2.
Right, there would just be an A and a B.
Right.
And no, yeah,
So BA and BB?
No.
just A and B. We'd have to, since
Oh,
there's
A
only
and
one
B. Oh, okay.
paragraph under,
4A, 4B, 4C.
Well, I think that all of that has to be rewritten,
okay,
because as I understand it, what we're doing is we're going to neutralize the executive director's role
right,
into simply a fact finder supported by whatever evidence that he has, and the original complainant can supplement it or take issue with it under the same set, and of course the respondent can do the same. So all that goes to the commission, and they have a full hearing on it, and then if they want to take more testimony or they think something else needs to be done, they'll do it. But eventually they will end up with a finding either of willful violation or not, and that's all in the hearing section.
okay, so Mr. Grossman, you had said earlier that you'd be willing to draft this new language to neutralize
Well,
the
I'm going to
executive
try.
director.
I'm going
Okay.
to try.
Okay, and this is only for willful violations,
Willful,
and
right?
we're going to make sure the
Yeah, because-
complainant
yeah.
has a,
Because our position is they don't have jurisdiction to handle simple complaints.
right, okay. So we can move on to section 5. Member Nee,
Well, I'd like to point something out in 4C,
okay,
and that is the final sentence in there. It says, the notice shall inform each respondent that he or she has the right to be present and represented by counsel at the hearing. And I have a problem with represented by counsel at the hearing in light of 67.21I.
Good catch.
And 67.21J talks about the right to be represented by counsel at a court proceeding. However, the Ethics Commission proceedings are not litigations. So I would,
Well, if a respondent wants to hire a private lawyer, he can do that, right?
I suppose.
He doesn't have
But-
to use the city attorney.
Well, then we should,
Yeah, that's right.
then we
We
should
know
say represented by private
Private
counsel.
counsel.
private counsel, okay.
They can call their union.
Section 5.
I'd like to remove the whole concept of a hearing officer.
Yeah, I agree. That's nonsense.
I mean, the commission may assign an outside hearing officer.
So strike that wherever it appears.
The commission may hold a hearing.
Yeah, listen, they have 4 lawyers on their commission. They don't need to hire an outside hearing officer.
Right. And maybe it should just say the hearing shall be open and public and shall be performed by the commission.
Well, do we want?
No, the commission shall hold the hearing.
Which shall be open to the public.
Well, do we want to strike where it says the commission may assign one of its members to hold the hearing?
Yeah, because they're using that member as a hearing officer. And that's what we don't want.
Well, they can assign one of its, I think that it should be the commission, but they may say, look, this is outside of our regular business and so forth and so on, even though it's supposed to be heard at our next scheduled meeting, right? So it has to be consistent with that, so let's hold them to that. They have to hold the hearing in accordance with whatever that section is, namely, what, 2 something or 3 something?
I'll just have a special section in their
Yeah.
agenda.
3B,
for
it
this.
says, shall schedule hearing at the next regular meeting of the commission. So, commission shall hold a hearing, a public hearing, at a special meeting in accordance with whatever.
And shall be performed by the commission.
Well, it looks like 1B is going to go away. Well, except for willful violations.
I'm sorry, I didn't hear that.
I'm looking at 1B.
Oh, well.
I would
well,
just strike
let's-
that completely.
1A is impossible. For referral, only 2 people can speak.
No live testimony.
Only 2 people, the original
public
complainant
comment?
and the respondent, and no public comment?
Well, it says no live testimony, but you can send in recorded testimony and have it played.
Walter can sing it.
Well, they put the word in there. Live doesn't say anything about
See how those-
reproduction or.
Those extra words.
Well, I think that there should be, I don't understand why the original complainant has to be the expert who can talk about record keeping. There were a couple of cases before the task force in which the question of backup tapes and storage and data came up. And only the metadata cases, and only in those cases did the task force, in those cases they had testimony from people who were experts. I remember in the metadata case particularly,
Right.
they had expert testimony, and in the data backup stuff, we actually got I think we got them to admit that we were entitled to it, but they wouldn't turn it over. But that took some doing because I knew nothing about IT and Chemo did, you know? So I think this is nuts. I think you need to have, just like in any court proceeding, because this is pretty serious, I think you're entitled to have witnesses to support your position.
I would say the other thing that's bothering me is the difference in pluralism between 1 and 2. 1 depicts an individual, singular, while 2 specifies more than one. So that it's just a semantical point. But I think also, you know, somebody from either this committee or our legal counsel, maybe with the charge that they are to, you know, explain how we came to the because if the respondent's going to say this violation is frivolous, I don't think it's, you know, it applies, it's valid or anything like that. At least there's some legal opinion that says this is definitely, you know, and there's some live person to say that instead of just words on a paper that may be written by a lawyer and may be on their letterhead, but they may not want to regard it.
Besides which, the commissioners may have questions
Right.
that the complainant doesn't have the expertise to answer.
And we're familiar with the case. The task force it's the referral from the task force. So why wouldn't we be automatically there
Well,
to respond to our own referral and defend it?
I think that you should be able to do that.
Well, if they're going to refute that, if, as in your experience, if they're going to refute our referrals to be, you know, invalid, then we should have every right to, if they want to create a official process, you know, the defense of our, it's our referral. It's not the complainant's referral. The complainant is just the one that benefits from it, and as you said, they don't have any of the details. We may have added items to the.
Well, they have the whole record from the task force, but
I just think that if we're there,
the problem is that the task force doesn't have an anointed representative that would represent the task force to defend its action in issuing the order. If it's truly an enforcement case, then everything that the task force has done, it should be bulletproof.
Yeah.
And the only issue should be the nature of the enforcement. That's going to be hard to deal with because, as you can see, the staff thinks it should be simply a burden of proof issue. And
So how about
those-
we put in there that the order of determinations by way of referral of the task force are indisputable.
well,
And
we may actually,
irrefutable.
we may come to that. In other words, when we describe the nature of the hearing, we can say that the issue, that the commission is, the issue before the commission is limited to the nature of the enforcement of the order.
That's right.
Not to
Okay.
the underlying facts giving rise to the order.
That's right. And that's really the crux of
Yeah.
what we
Well,
want to do.
That's what one of the big fights is going to be.
Yeah.
And we have to convince them that that's the best thing for them.
So where should that language go? Should that go before A? Kind of a preamble for 5? Or should we have a new A, which speaks to their purview, or whatever we want to call it.
They almost need another number, like they have standard of proof, burden of proof rules. They need like findings of fact that says the sunshine ordinance.
I don't think you need to, because we've done all that work for them.
No, but stating that,
Oh,
that it's ours, because that's where that language comes from, that you can't dispute the findings of fact of the sunshine ordinance.
mhm.
But or whatever you said.
You can't re-investigate, or you can't relitigate.
Yeah. Well,
Double jeopardy.
I don't know if you read my memo or not, but I dealt with this on page 3 at the top. Again, if you listen to the discussion before the commission on those 3 original decision points regarding jurisdiction, there was quite a bit of talk about what was the nature of the hearing going to be, if it was enforcement or something like enforcement. And I was quizzed at length about my suggestion that it be a show cause hearing, which I thought meant, here's the order, show cause why it shouldn't be enforced, which that was my business lawyer's understanding of it. But as it turns out, according to Susan Harriman, a show cause hearing could go further and hear evidence on the underlying case. So I abandoned that, and I said, well, then it's really like the penalty phase in a civil proceeding where there's been liability has been found, or in a criminal case where the individual has been, the crime has been
Committed.
committed, and then the question is, what is the court going to do by way of a penalty, probation or whatever? But this is going to be a big fight. So I think part of what we do is to decide what our position is going to be and how strongly we're going to stick to it, because we're going to get a lot of pushback from maybe. But on the other hand, I think that we may get a couple of the commissioners to agree with us. I think Ben-Hur made 1 or 2 short comments where he thought it should be a short summary proceeding. He saw no reason to replicate what the task force had done, and their job is just to decide the penalty.
Good.
So I think if we stick to that, we will we'll have a decent chance of getting it.
Well, I'm wondering, since they do have sort of original jurisdiction for those cases brought to them for willful violation, maybe we could have 2, I don't know if it would be suggest another Roman numeral or split the hearing into 2 sections.
Yeah, well, there should be different kinds of hearings.
Right.
One on a willful violation and one for enforcement of a referral.
Right.
And they shouldn't be lumped together.
So we should have 2 separate sections.
Right.
So a Roman numeral 5 and a Roman numeral 6 at another level, or another
Well, you can have
major heading
yeah,
there.
Or you can have A and B, and then move, general rules and procedures for a willful to number 1. It's just formatting. But because hearing, it should be all under one rubric.
Okay, all right.
So-
The thing is, and this is, again, I think when I spoke before the full task force, I mentioned that these regulations have to be carefully crafted by lawyers who know how to write. And if you look at the hearing provisions, you can see the problems with the way in which they're supposed to apply in one case versus another. So that they use terms as if they applied to both, which they can't. So I think that in the long run, we may have to actually do the drafting for them. But,
love that.
again, I was going to ask the committee, I wanted to know whether the city attorney had reviewed the draft.
I don't know.
I'd like to find that out, because if the city attorney hasn't, then I'm not even sure that they should, that it should be move forward until that happens, because of the inconsistencies within the document.
Member Nee?
Yeah, just a quick question. When you say the city attorney, do you mean the city attorney's office or the deputy city attorney assigned to the task force? Who
No,
you're
I
referring
mean
to?
the one that advises
The task force.
The task-
the Ethics Commission.
Oh,
I don't
What-
think I don't think he's a city attorney. I don't think they have a.
Yeah,
maybe they
they've
do.
got
I guess they do. Yeah.
Givner.
They do.
John Givner is,
Yeah.
Okay.
is there all the time.
Um,
And they have actually two. They've got a guy named Chen or Shen. They have 2 or 3 lawyers that work for the Ethics Commission. And I don't see the hand of a really polished lawyer in this draft. And that's why I think that they should have had it reviewed, just to make it a better written piece of work. And then you could focus on the nuances rather than dealing with some of the basic, building blocks, which is what we're doing.
right, but you're not suggesting that we ask them to do this before we proceed, because
No,
we
what I
can,
was going to do is put in a records request for that or an information request,
oh, okay.
and see what I get back. But I'm not looking to create any waves with the Ethics Commission right now. So unless you think it's that there shouldn't be any problem doing it, I won't do
Oh,
it.
yeah, no, yeah, I think that would be fine if other
Okay.
members agree. I'm wondering, could we recommend that Member Snyder look at this, since he's a litigator, look at Section 5
well,
and suggest
yeah,
some
well,
language for us?
Right,
or-
I think he should, definitely. But I think it's just way too cumbersome, and it's too much to ask of a complainant, you know?
A litigator to look at, if it's a referral, you're talking about just for the referrals?
No, to create the process
For
To help.
referrals?
for, I guess.
Well, for
is it-
both, because we
for
have
both.
problems with the way they're handling the willful violations. They have no,
Right, yeah.
there's no voice for the complainant.
Yeah.
Because you don't want it to be relitigated.
Yeah.
Right.
Well,
So you
and
wanna
the-
be
and the
careful
So you
how
want to
you
be
write.
sure that there's no, they don't have any sneaky ways of being able to.
Well, they have actually, because what they've done is, if you look at 5C, my impression is that the violation has to be willful before the commission will impose penalties. So what they're doing is they want to shoehorn this enforcement question into the willful violation area in order to do the penalties. So they may say, well, yeah, there was an order and so forth, but it wasn't willful. Well, come on, you know?
Yeah, because they see that their work is only with willful,
Right.
right? And we're saying, no, you have if something's willful, yeah, you deal with that on your own. But the regular complaints that come through the task force also have to be dealt with accordingly for enforcement. It's not just willful that gets enforced. It's everything gets enforced.
And there's a lot of language in there that's vague, like in 5C, that if it's willful, whether they've failed to comply within the appropriate time frame for good cause is vague and ambiguous and can be interpreted in a million ways.
I know, well, throw it back on them for saying that the ordinance doesn't describe what filing a complaint means. Well, what does good cause mean then? It's like that. I'm wondering, the one thing that we could probably glean from is after their investigation has found a violation of the ethics code, then the staff makes a recommendation through the executive director to the commission that there is in fact a violation and penalties there needs to be enforcement and penalties. What is then the process? It's already agreed and accepted by the commission in part one that there is a violation. So now that there's a violation, they move to the enforcement and penalty phase. I just want to look at the enforcement and penalty phase of how they currently manage violations of what they currently, in their current jurisdiction.
I think from our point of view, though, if you look at B and C on page 7, and going all the way down to D and on H, you'll see that they forgot, they've lost the referral type of action, enforcement action, and now only talk about violation.
Right.
Okay, yeah.
So, in order to get a remedy on a referral, they also have to find that the original violation was willful. Well, that's not right, because the issue of willfulness is not before them on a violation, on the enforcement of an order. The only question is, what's the penalty? Because they've already had their crack at compliance and they've not done it. So much of B and C is inappropriate to referrals. Then if you look at 5 on page 8, some of that is relevant and some isn't. And but of course, there's no investigation in a referral case, but they talk about it as if there is. And then finally, at the end, they say if there's no violation, they announce that. And they take no further action on the complaint. And the executive director informs each respondent, the complainant, or the original complainant for task referrals of the commission's determination. So all of this that precedes that it covers referral cases as well as willful violation cases. And that's not the way it's supposed to be. They're supposed to have 2 different set of rules. So that has to be fixed. Then, of course, they've got this confidentiality. If you look at the top of page 9, this creates a defense, an absolute defense to any violation.
I have a question about that.
Yeah.
Their memo says absolute defense, but this language just says is a defense. Well, that doesn't mean it's absolute. Lots of things are a defense,
Well,
but that doesn't mean that it's...
If you think that when they say defense here and absolute defense in the memo, that they don't mean absolute here, you haven't dealt with that bunch over at.
I know that's,
commission.
but that's a mistake on their
Well,
part,
it's-
but we should also correct it.
Yeah, but you're arguing over the wrong point. It shouldn't be in here in the first place.
Right.
So,
But I don't think they're going to take it out either.
pardon?
I don't believe that we should act only on the idea that they'll take it out, because it seems like a lot of this is structured to give them more power. And if they don't take it out, we need to address some of these things.
Well,
What's the alternative?
But what you don't understand is this is the charter versus the ordinance trumping issue, because they only refer to the non-confidentiality provisions in the CPRA and the Brown Act as defenses when they may not be exempt under the ordinance. So they'll say, well, we don't recognize the ordinance as having the same authority as the provisions in section Appendix C and Appendix F, which are parts of the charter. So we don't recognize that the exemptions under the ordinance would apply, meaning the non-confidentiality provisions. So that puts us right in the middle of this trumping question, you know, because if you just limit it to the CPRA and the issue is covered in the ordinance differently, then you're going to have a fight on your hands.
Member Wolf?
Let me propose this question.
I think we ought to just have them take it out.
I would agree with you, because under what we currently do, that what they're basically saying is that would apply to what we currently do.
I agree with you, but what if they don't take it out?
I'm sorry?
I agree with you that we should ask them to take it out, but what if they don't?
Well, the point is are they then making an interpretation of a defense that can be used here at the Sunshine Task Force? Because
There are
that's
all
basically
kinds
what
of-
they're saying.
There
They're
are all
saying,
kinds of defenses. I mean, there are affirmative defenses, and it doesn't mean they're absolute.
I understand that, but they are putting something in words that doesn't exist anywhere. And that is the concern I have. You know, once you create a message and you make it public, you tend to own it unless somebody, you know, challenges it and it gets stricken from the record. This is becomes a legal document. So I'm concerned that they have this in here at all. The finding of no violation, it's not in their purview, except for willful, because willful is of their own accord. It has nothing to do with us. Except in a referral by us that shows willful, which they probably would re-adjudicate.
Well, the thing is that there are a number of exemptions in the
CPRA?
CPRA that are removed by the ordinance. The balancing of the public interest versus the private one, and you know, a couple 6255 or whatever. And this would keep those available as a defense to any case alleging a violation, a willful violation, or even a order for enforcement. And as I say, what it does is it takes out of the realm of this real issue, this little issue, the issue of the trumping. And there's a lot to be said on that subject, and this isn't really the place to do it. I think I gave Susan Harriman a memo on that, but it's an ingrained view in the city attorney's office, and it's just wrong.
Okay, I'm looking at the clock. We're almost to the end of this meeting, and with regard to Section 5, I'm wondering, Mr. Grossman, if you could contact Member Snyder and give him in broad strokes some ideas about how to whip this into shape in accordance with our discussion here. I think we have some consensus on the need to clearly separate their complaints of willful violations from matters that we refer to them, in which case the hearings are really, I think the analogy to a penalty phase hearing is a good one. So,
I just
Member
have a
Johnson.
question about I know we're going to send the Ethics Commission our recommendations, and clearly we're going to ask them to, not that their jurisdiction, their idea of jurisdiction is incorrect about being able to hear the simple complaints. Are we going to have opportunity, if they won't take that out, to propose different language? Are we going to do that anyway, or are we just going to do all or nothing? I'm just curious what our, like, if they won't take that out, we do want to be able to have some kind of input in how it's written, right?
Well, I hope that we'll be at that meeting, first of all, when that happens, and that if they want to pull it out, if they don't want to pull it out, that we have Plan B.
Right.
We have alternate language that would equally be,
Better than
the
not.
equivalent of wiping it out. And if they don't like that still, it's at least on the record that we disapprove of what they're doing. And then we can then argue that to the powers that be, that what they're doing is, we can make a federal case out of it if we want,
Or we can put it in the amendments to the Sunshine Ordinance.
Yeah, we could do that too, and we can also take out a full-page ad in the Chronicle, and,
But I think what we need to do now is to get, a draft of our recommendations together, and so we kind of are on the same page about what we're thinking.
Well,
See how it goes at the joint meeting.
Yeah, I was also going to ask you where you think your city of DCA fits into this project, Mr. Threet.
We had asked them about that. That actually probably flows in the same line as what happened with the amendments. And that is after we are all done with all our deliberations, he would then take a look at the whole package of all our edits and our suggestions, so he could see them as a body of work rather than piecemeal. That
And
was
what would his role be, just to make sure we've got the Ts and the crossed and the Is dotted?
No, he would
He
he
could-
would make sure that we didn't cross any lines, as far as the law is concerned. Do we overstep our bounds? Or at the same time, that was I believe was his words, so. But,
We want to overstep our bounds.
well, yeah, but, I mean, look, this is an internal document. This isn't bound by really any law, so.
We haven't even signed off on it yet because it's not done. So we'll be scheduling another meeting of this body for the 27th? Okay. Do I hear a motion to adjourn tonight's meeting?
When is the next meeting?
27.
October 27th?
That's a full task force.
No.
No, it's
Oh,
us.
the
It's
night
the night after. It's just us.
Okay.
Do I hear a second?
Second.
Okay, without objection, the meeting's adjourned.